similarly, proforma defendant number 5 have also occupied a part of the land, and same thing is there. And they subsequently they have surrendered the lease to the plaintiff.
Who?
Proforma defendant number 4 and 5. They have surrendered the lease, and thereafter, my lord, this defendant number 1, 2, and 3 had entered into the suit.
Whose document was those? Exhibit 8 and 9?
Exhibit 8 and 9 is written by defendant number 1 to the proforma defendant number 4 and 5, seeking permission to organize some function on the land.
Now, did you claim adverse possession?
Yes.
Was it an alternative plea or main plea?
Lord, I am the defendant. My plea is that, my lord, since we are in the suit land for more than, my lord, 22 years, so we have claimed the right by way of adverse possession.
Okay. Meaning thereby, you are claiming adverse possession against whom?
My lord, against it should be against the plaintiff. My
Okay.
lord.
So thereby you are admitting the plaintiff's title. It has to be. There's no quarrel with that proposition. That's the law.
But,
so you admit that the plaintiff is the owner.
But in the cross-examination, they say that, my lord, the defendant says that, my lord, they do not know if the actual owner.
Then adverse possession falls like a pack of cards. So that adverse possession question does not arise. So what else right do you have to remain in possession of the plaintiff? Did you have any other plea taken? Let's see your written statement.
Okay. Written statement is at page 49 of the evidence. Paragraph 14.
So your entire case is that. Now, what is the what are the exhibited documents of the plaintiff?
The plaintiff has exhibited 18 documents.
What is did you exhibit the document of title?
Yes, my lord. We had exhibited the patta, the jamabundi, the revenue receipt.
The records are in there. The patta is in terms
menu.
with the schedule.
Yes.
My lord,
Okay.
in patta, my lord, the name is, my lord, Messrs. Johar-Mal Murlidhar and Company. And in, my lord, Jamabandi, it is written Messrs. Johar-Mal Murlidhar. And, my lord, the suit is filed by Messrs. Johar-Mal Murlidhar and Property. My lord, PW1 in his cross-examination stated that Messrs. Johar-Mal Murlidhar Company and Messrs. Johar-Mal Murlidhar are two different entities. One is a company registered under the Companies Act, another is one HUF, Hindu Undivided. And, my lord, later on, the HUF was discontinued. Then, my lord, this Johar-Mal Murlidhar Properties is formed. But with regard to that, there is no pleading. And, my lord, the document, the title, to show their title, they have exhibited two documents, my lord. Exhibit 3 is Patta, Exhibit 4 is Jamabandi. In both the documents, my lord, the name of the plaintiff, the name of the plaintiff is not there. That's why the trial court has come to a finding that the plaintiff is failed to prove his title over the suit land. Exhibit 3 is Patta.
Patta says what? Message
Messrs.
Johormal Muralidhar.
Johormal Muralidhar and Company. But in the top, the it's written by hand.
And how is exhibit 8 and 9 has relevance?
Well, exhibit 8 and 9, the plaintiff wants to say that since the pro forma defendant number 4 and 5 are in possession of the suit land, that's why my claim that I'm in possession of the suit land for more than 22 years is not tenable.
That has no relevance.
My lord, exhibit 4, my lord, that is Jamabandi.
And defendant number 2 has not appeared. Has he given any evidence?
My lord,
There's no defendant number 1 who's evidence.
yes, there is- in the judgment it is stated. DW1, DW2, both have.
Where is the evidence of DW Raju Dutt? Raju Dutt.
Raju statement.
Raju Das says in his evidence cross, I cannot say whether our land was purchased from the plaintiff. I do not reside over the suit land. Ujjal Bora also does not reside over the suit land. Ujjal Bora is residing on the other side, but I do not know who owned the suit land. It is not a fact that we tried to trespass into the suit land on Iman or being vacated by the lessees. I do not know whether there was any police case for the same. But once police went to the spot and asked us to vacate the suit land, I do not know whether the police came on the complaint of the plaintiff or not. It is not a fact that the letter of the DW2 went to. It is not a fact that I am deposing falsely and I am in possession of the suit land since 20. Yes, what do you say about this particular document, Exhibit 4 and 5? Why the patta says Messrs. Johormal, Murlidhar and Company?
Lord, there has been a mistake, and in fact, PW3, that is the land revenue staff, had clarified that position, Manoj.
Where?
At page 19, if your lordship takes up. Lord, findings in the judgment is at page 19.
Read the cross of PW2 3
3, Manoj.
cross.
15/2/2006 তাৰিখৰ পৰা মই ডুমডুমা ৰেভিনিউ চাৰ্কলত CO হিচাপে কাম কৰি আছো। তাৰ আগতে মই লংকা ৰেভিনিউ চাৰ্কলত আছিলো। ই মাটি কেতিয়াও দেখা নাই, বিবাদীয় মাটি কেতিয়াও দেখা নাই। বিবাদীয় মাটিৰ বৰ্তমান কাৰ দখলত আছে মই নাজানো। 15/2/2006 অংশৰ তাৰিখৰ আগতে কাৰ দখল এই মাটিত আছিল নাজানো। মই অনা ড্ৰাফ্ট চিঠা আৰু জমাবন্দীৰ সংশ্লিষ্ট পাত্তা দাগ দাগত মূল এটা
ভুল এটা
ভুল এটা আছে দাগত ভুল এটা আছে লাষ্ট সেটেলমেন্টৰ সময়ৰ পৰাই এই ভুলটো জৱাহৰলাল মুৰলীধৰ পাট্টাদাৰৰ নলেজ আছে নে নাই মই নাজানো বাদীয়ে উক্ত ভুল কাৰেকশ্যনৰ কাৰণে কেতিয়াও দৰখাস্ত দিয়া নাই লাষ্ট সেটেলমেন্ট অপাৰেশ্যন 1970 হৈছিলে তেতিয়াৰ পৰা উক্ত ভুলটো COA পাৰ্টিক জনাইছে নে নাই মই নাজানো ময়ো পাৰ্টিক এই বিষয়ে জনোৱা নাই সিডনী ডাগলাছ চিনি নাপাওঁ তেওঁ বিবাদীয় মাটিত দখল কেতিয়াবা আছিল নে নাই মই নাজানো মই মাটিত তেওঁৰ অধিকালত আছিলো নে নাই নাজানো মই অনা নথিত মেছাৰ জৱাহৰলাল মুৰলীধৰ প্ৰপাৰ্টিজ নামেৰে কোনো নামজাৰি নাই মেছেজ জৱাহৰলাল মুৰলীধৰ প্ৰপাৰ্টিজ বিষয়ে মই কোনো মাটি নাই বা নথিত এই বিষয়ে উল্লেখ নাই মোৰ নথি মতে বিবাদীয় মাটি জৱাহৰলাল মুৰলীধৰৰ নামত আৰু যদিও জৱাহৰলাল মুৰলীধৰ ফাৰ্মটো এতিয়াও এক্সিষ্টেঞ্চত আছে নে নাই মই নাজানো সিডনী ওৱেন ডাগলাছ বিবাদীয় মাটিৰ মালিক আছিল নে নাই মই ক'ব নোৱাৰিম মেছেজ জৱাহৰলাল মুৰলীধৰ মানে বাদীয়ে কেতিয়াবা খাজনা দিছিল নে নাই নাজানো গোচৰৰ বাদী বিবাদীগণক মই চিনি নাপাওঁ নামজাৰি দিবৰ কাৰণে দৰখাস্তকাৰীৰ দখল থাকিব লাগে সত্য নহয় যে আদি প্ৰদৰ্শিত নথি মতে এক্সিবিট 19 এখন জাল নথি হয় ৰেভিনিউ ৰেকৰ্ডত যি পাট্টাদাৰৰ নাম ৰেকৰ্ড কৰা নাই তেওঁৰ মৃত্যু হলে লিগেল এয়াৰ্ছৰ নামত ৰেকৰ্ড জানিবলৈ হলে পাৰ্টিয়ে পিটিশ্যন দিব লাগে বিবাদীয় মাটি চৌহদ মই ক'ব নোৱাৰো বাদী বিবাদীক যিহেতু মই চিনি নাপাওঁ বিবাদীয় মাটিৰ মালিক কোন মই নাজানো
and see the clause of TW1.
Should I read it, Manoj?
Should
I read it?
TW1.
Yes. The defendant had
Third paragraph. Yeah. MS Jawaharlal Mullidhar.
Mrs. Jawaharlal Muralidhar Properties and Mrs. Jawaharlal Co. are two concerned. Mrs. Jawaharlal Muralidhar Properties was an HUF, and after dissolution, it became JM Properties. We have family documents to show conversion of HUF to Association of Persons, but no document has been filed in this court. Mrs. Jawaharlal Muralidhar Co. is a company and it will be still in existence. Mrs. Muralidhar the HUF is now abolished. Exhibit G is the patta of the suit land. This patta stands in the name of Messrs. Jawaharlal Muralidhar and Co. In Exhibit G and H, plaintiff's name on as Messrs. Jawaharlal Muralidhar Properties is not appearing. Similarly, in Exhibit 1, 6, and 7, the plaintiff's name is not appearing. The plaintiff never paid the taxes for the holding of the suit land. It has been paid by Douglas family. There are two holding in the suit land. They are 132 and 133. These two holdings are constructed by pro forma defendant jointly. They have individual rights as a lessee. Pro forma defendant at the time of final delivery of possession had dismantled these structures and delivered the vacant possession of the suit land. Plaintiff had leased out the suit land to the pro forma defendant about 30 years and it was leased out by Messrs. Jawaharlal Muralidhar HUF. This lease in question was verbal. No terms and conditions were made in the lease. Pro forma defendant OP number 4 had paid rupees 150 as rent, and the father of the pro forma defendant number 5 paid rupees 100 for the holdings. Like payment of rent, we had issued rent receipts. About 5-6 years ago, they stopped payment. Till 4 and 5th September 2004, the lease was there. After that, no lease is there. There is no any document in respect of the surrender of lease. The members of Messrs. Jawaharlal Properties are Binod, Sajjan, Om Prakash, and Neeraj Chokani. About 6-7 years back, the Association of Persons were constituted. It is not a fact that the suit land was never owned and possessed by the plaintiff. It is not a fact that all the above named 5 persons are members of the plaintiff's association. Plaintiff is not a registered body. It is not a fact that the plaintiff had never leased out the suit land to the pro forma defendants. It is not a fact that pro forma defendants never paid any rent relating to suit land. It is not a fact that the suit land was never possessed by the pro forma defendants. It is not a fact that the plaintiff had not paid any revenue in respect of the suit land. It is not a fact that the pro forma defendant had never paid any holding tax in respect of the holding standing on the suit land. The defendants have occupied the suit land on 6/10/2004. The defendants are still in possession of the suit land. Raju Das is a party in the suit. It is not a fact that Raju Das, the defendant, has been occupying suit land since then. He has been possessing the suit land.
How do you connect Jawaharlal Properties with you?
Lord, there's a small history behind it, my lord, and in fact, Exhibit 15 would perhaps show light on this, my lord. My lord, Jawaharlal Muralidhar was a greater body, an HUF, my lord. From there was a partition, and few of the members had separated. Now, they, in respect of that co-owned share, they formed this association.
Now, see the Jamabandi 39. It has been shown as Messr Jawaharlal Muralidhar. What is this then? Makum.
Maku.
Messr
Haan, yes,
Jawaharlal
Makum.
Muralidhar.
Muralidhar.
What is that?
Jawaharlal Muralidhar, it should have been Muralidhar property. Jawaharlal Muralidhar is a breakaway fraction from the HUF, my lord. And that is what has been an association of persons.
What are you saying about 15 and Exhibit 15?
15, my lord.
Is some power of attorney.
Yes. 15 and 20, my lord. My lord, from this we know that internal page 3, if your lordship takes up of 15, Exhibit 15.
Hmm?
Internal page 3 of Exhibit 15. The recital, my lord.
Yeah. There's a party above name that only come to the last. And whereas the properties allotted to the parties hereto by the family settlement dated demand, and as per the terms embodied therein, also came to own as tenants in common and in equal shares in the association of persons known as MS Jawaharlal Property with effect from 1st day of April 1999. Now, if that be so, is association of person a juristic entity?
My lord, here I would say, my lord, if your lordship also takes up Exhibit 20, that's the agreement among the co-owners. My lord, so far as the defendant is concerned, my lord, he's admittedly a squatter. So therefore, my lord, if it's a co-owned property, my lord,
No, therefore, if it is a co-owned property, one person can very well then. But is any co-owner before the court?
yes, my lord, as a representative of the association.
Of the association of persons?
Yes. Now, even
Now, whether a
even
representative
individually, he
of
has
an
the right,
association of persons
my lord.
can be said to be a person concerned?
My lord, as per the General Clauses Act, a person would include an association of persons incorporated or unincorporated. Now, if we go by the land law, also, my lord, it says person, my lord. So does Order 1, Rule 1. So, my lord, if we go by the general meaning, then an unincorporated association of person is also a person, my lord. Now, of course, there are perhaps a few judgments by the High Court which have said that the association of persons not complying with Order 1, Rule 8, such suits may not be maintainable. But those are in the context of clubs and those informal associations. Lord, given this scenario, my lord, it is apparent that these 5 persons were co-owners, my lord. Now, these co-owners had pooled in their resources to form an association to manage the properties. So, internal page 5 of the exhibit 20, if your lordship takes up the first clause.
Then in that case, whether section 69 would not hit you?
But 60 we are not claiming to be a partnership. No.
But
We are only an association of persons.
so an association of persons can file a suit.
Considering that it's a co-ownership, my lord, and because ultimately, though it is styled as an association, my lord,
No,
these
if
rights
you-
have flown out of
If there
inheritance.
there were two plaintiffs, the association of persons represented by so and one of the owners also could have, there's no problem. But
He's on
without-
record, my lord.
Huh?
Sajjan Kumar, who's my lord, filed the suit, my lord. He is also a co in that very same association of persons. He was just appointed as the manager among the 5. So, my lord, otherwise, perhaps this issue could have had some significance, my lord. But since it's an appeal by a person claiming adverse possession, my lord, so much detailed investigation into my capacity to sue on
no,
behalf of-
there's no problem with that. Problem is not by that, adverse possession.
Madam.
He, but yes, there is okay. You can vacate him.
Yeah.
But can this court give you possession? It's a difference. You vacate him, it's okay. You can vacate him.
Madam.
He has no right. Are you entitled to? First, you have to be entitled to.
Madam.
That, for example, tomorrow, if we accept your proposition, you may very well say tomorrow, any person may bring somebody, ABCD, who has nothing to do with the property. Let's take an example of that. A plaintiff A wants a particular property, this particular, and that person concerned, the plaintiff A makes plaintiff DCD as defendants. And that BCD claims adverse possession. His suit may be decreed. These people may not have a right of adverse possession, they have to prove it here. But whether their acceptance that you are the owner can be said to be an owner to get a decree for recovery of possession
My lord,
or
recovery.
declaration of your title, because otherwise it will have a far-reaching consequences.
My lord, so far as declaration of title is concerned, my lord. Now, my lord,
You are asking for declaration and then recovery.
recovery, my lord, may not be necessary, my lord, because it is under attachment. So it's under custodial legis. It'll come back to me, my lord.
Is under
Attachment
under whom?
by under 146, my lord, CRB.
How is it continuing? Attachment is for 2 months,
My lord, but because the suit was pending, it was extended.
every 2 months.
My lord, there is no prayer for recovery.
There's no prayer for recovery.
My lord, which is why I said, my lord, if
My lord, page 38 is the plaint, page 47 is the prayer.
Yeah, that's it. That's-
37 to the-
What is your plane? Let us see.
But it starts from page 38. And prayer 47.
Permanent injunction restraining them so and so claiming under remand under them to enter into the suit. And why are they therefore asking for adverse possession if they are not in possession? And you are not asking for recovery.
My lord, two propositions I will rely on this, my lord. Number one, my lord, during evidence it has come out that the land is vacant.
That
Now-
I have seen.
Now, my lord, going by the proposition in Anantala Sudhakar, my lord, if it's a vacant plot of land,
It goes back to the
possession
title.
would be deemed to be with the title holder.
So the fact and then why the suit is required? Why you asking for declaration against them?
Lord,
The suit becomes meaningless.
and the second being, my lord, I did not claim for recovery because as per the Supreme Court, my lord, if it's under attachment, then it's in under custodial legis, meaning nobody has.
But the Supreme Court also says that this attachment can be only for 2 months unless it is extended. How do you take care of that?
My lord, that procedural irregularity in
You cannot go for ahead with an attachment for all life. And this suit was filed in 2010. For the last 14 years, you are saying the attachment continues. Oh, not 14, 20 years.
no, my lord, given that it is vacant, my lord, I need that because since it's a cloud and I need to injunct them, my lord. So therefore, if it's
In
vacant,
fact, it
possession
seems
will
that
be
both of you have to join together to file a suit and
Okay.
continuing it for 20 years. Seems something like that. He is not in possession. You are not, you don't are also not in possession. But if you are asking, just for example, you are, another question arises, Mr. Gupta. Whether 34, the proviso to 34 would not apply. The further relief.
My lord,
which is why I'll just place 64 once.
Eh?
And, Lord, if the possession is deemed to be with me, my lord.
How can
And-
it be deemed to be? Then you see, you are not asking for. What then? Where if you are not asking for it and you are not in possession, are you in possession? Show me where you have mentioned
paragraph 5 of the plaint.
when they violated. Here you categorically say in the page 46, paragraph 10, that a cause of actions of the suit arose on Iman when the defendants illegally encroached into the suit land and affixed a signboard of Warrior Club on so and so. And when they violated the order of so and so, made criminal charge and subsequent on all other dates within the jurisdiction of this court, meaning thereby they are in possession. Now, this further relief having not been sought for, why should the court issue a declaration in your favor?
My lord, I would argue it's not necessary.
Why?
My lord, first, because of the proposition that since it's vacant, the title holder will be deemed to have possession, my lord. Number one, this
Then
attempts
your
of
cause of action for the suit is not there, is vacant. They are not encroaching. That is why I'm asking. They are not encroaching.
they're encroached, my lord. After that, we moved that 146 application.
That means after, during the pendency, they must have released it.
My lord. So therefore, at least I'm entitled to a
You can't
permanent.
get a declaration against somebody, trespasser out there. So you can't get that declaration for your right to the title. First of all, you are not a part, you have no business out there.
My lord, if I may just read those 5 parameters of Anatala Sudhakar, when I should sue for declaration and when for possession.
Yes.
Lord, where number A is where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a cloud, but he is out of possession, he has to sue for possession with a consequential injunction. Where there is merely an interference with the plaintiff's lawful possession or threat of dispossession, is sufficient to sue for an injunction simpliciter.
Subsequent,
Lord, where-
sufficient for having a permanent injunction.
Yes.
Yes, then
As a suit for injunction simpliciter concerned only with possession, normally the issue of title will not be directly and substantially in issue. The prayer of injunction will be decided with reference to finding on possession. But in cases where de jure possession has to be established on the basis of title to the property, as in the case of vacant sites, the issue of title may directly and substantially arise for consideration, as without a finding thereon, it will not be possible to decide the issue of possession. Now, there are other parameters.
because in your plaint, you categorically mentioned that there was an order passed by the district magistrate for drawing up proceedings under 144 and by the order dated restraining the defendants 1 and 2 and associates from entering into the suit land. The defendants, who are the men of desperate nature, violated the order of again trespassed into the part of the suit land and affixed 2 numbers of wooden sport. Thereafter lodged a complaint regarding with an ejahar with the officer in charge, Makum Clan, intimating the violation of the order of the court and paid for doing the needful. The plaintiff further, on so and so, in anticipation of the further attempt by the defendant, filed another petition under Iman to convert the proceedings into 145 and also prayed for attachment for breach. And according the lawyer converted the proceeding and also ordered to attach the disputed property. That accordingly, the OC so and so on attached the disputed in pursuance to the order dated 19/11/2014. The aforesaid acts so and so needs and have cast a cloud over the subsisting right, title, and possession. Cast a cloud over the subsisting right, title, and possession of the plaintiff over and in respect to the, and as such, the plaintiff files the suit for Iman, title, and possession over in respect to the suit land and also for other reliefs. Now I again argue another judgment, 87 Supreme Court. It is there in the plaint, may not be there in the reliefs. Hopelessly drafted.
And there's a prayer for mandatory injunction also for removal of the signboard. That's the only act of trespass. The installation of the
So
signboard.
they are not in possession. Merely because they claim adverse possession, do you become the owner? Unless you show your ownership on the basis of some document.
Documents, otherwise, the document of title is there. It's just that there's been an error in the spelling. And so
Error of the spelling.
Jawaharlal Muralidhar Properties is missing.
And Co. is a company.
And firm.
How did you what you call demerge those properties out of the company? Is the company still in existence?
Therefore, I relied on
If it is in existence, then you have to either sell it or demerge it. And if it is a case of demerger, it will have to have it can't be your personal property unless that company was a partnership firm.
That is why I said, title here, of course, would be only ancillary in issue because it's a versus an encroacher. So, such a detail.
First of all, you have to have the title. On the basis. Now, how did you get the title from the company? Show me that.
Exhibit 20. Exhibit 20. It
The-
belonged to the larger HUF,
No, but your document shows that it is in the name of some company.
Company perhaps is a mistake. which is why the appellate court also came to a finding that there could be some
Let us see how the appellate court have done it. And when they claim that they are in possession for the last 22, 25 years.
Defendant number one, in cross-examination, it is stated that the defendants are in possession, plaintiff number one, PW1, it is stated that defendants are in possession of the suit and etc.
but they also say that it is lying vacant.
Lying vacant, but possession is theirs.
Well, that is
Lying
why-
vacant, they have put it, they don't stay there.
Board, signboard.
No, they have put a signboard out there. This is our land, Warrior Club.
Lord, which is why I said, my lord, ultimately, if it's vacant,
Let us see the appellate order.
page 8 it begins, my lord. Page 19, your lordship finds the discussion on title.
But the problem, otherwise there was no, unless some document was brought. Kindly come to page 21. Here, see, the circle officer that to establish so and so, the circle officer, it is seen that the suit length stands in the name of the plaintiff. Eh, no, sorry. Itu uthaw. 22 not 20. The name of the plaintiff, which was wrongly recorded during the resettlement of the name of Jawaharlal Muralidharan and Company. The learned civil judge held that the plaintiff had also failed to prove possession, but when a suit itself is filed for recovery of possession, it is not needed that the plaintiff is in possession since he has been dispossessed from the suit land according to the plaintiff. How do you take care of that? And then come to the proviso to section 34.
Section 34, my lord.
This is the relief you should have sought. You have not sought for. Why should we grant you the declaration?
My lord, prayer D should suffice, my lord, at page 47.
What is that?
The mandatory injunction for removal.
Mandatory injunction for what?
For removal.
For removal of what?
My lord, everything of Warrior Club Makum.
So you remove only that. Then you don't want the possession.
Possession, my lord, just 1-2 paragraphs of the judgment, my lord, considering it was para 4.
Para?
4. In our view, a suit for declaration of title to property filed when it stands attached under section 145 of the code, it is not necessary to ask for the further relief of delivery of possession. The fact, if it be so, that in the case of an attachment, case of such an attachment, the magistrate holds on behalf of the party whom he ultimately finds to have been in possession, in our opinion, irrelevant. On the question, however, whether the magistrate actually does so or not, it is unnecessary to express any opinion in the present case. The authorities clearly show that where the defendant is not in possession and not in a position to deliver possession to the plaintiff, it is not necessary for the plaintiff in a suit for declaration of title to property to claim possession. Now it is obvious, see so and so, so and so. Now it is obvious that in the present case, the respondents were not in possession after the attachment and were not in a position to deliver the possession to the appellate. The magistrate was in possession for whatsoever reason, it does not matter. And he was not, of course, a party to the suit. It is pertinent to mention, pertinent to observe that in Nawab Humayun Begum versus Nawab Shah Muhammad Khan, it has been held that further relief contemplated by the proviso to section 42 of the Specific Relief Act is relief against the defendant only. We may add that in K. Sudaresha Iyer versus Sarvajana Kiabal Virdhini.
What do you say about the Ganga properties case after
It was
later
held,
on?
What?
Ganga properties. Supreme Court says if you don't ask for the further relief, how can you get?
my lord, if it
First
is,
of all, where is it in your statement that it was continuously in the protection? It is still under attachment.
my lord, at the time of filing of the suit, my lord, I had made a statement that it was attached in pursuance of.
No, it was attached then, but then also they have violated. That is your case.
My lord,
This attachment order was already, my lord, disposed of on 29/3/2005, that is at Exhibit 14, by saying that since a civil suit is pending, therefore the proceeding is under section
but it was
144
never
is not
specifically
maintainable,
released.
and therefore the Exhibit 14.
And not only that, where have you mentioned in your plaint that on account of being in attachment,
Not
we are
said
not
in so many
asking?
words.
Then
My lord, further relief, my lord, how I couch it is, of course, relevant, my lord. But
Very
so,
relevant.
so far
and
as
more particularly in view of Ganga properties, where the person concerned was 1972. Supreme Court categorically says where he was supposed, he had not asked, he has only asked for declaration, but no the recovery of possession.
My lord, if I may just place those paragraphs, my lord, on.
Of
My lord, that 2008 judgment.
what does it say?
My lord, my lord, where the title of the plaintiff is not disputed, he is not in possession, his remedy is to file a suit for possession if necessary.
No, it is also categorically observed by the first appellate court that you are not in possession. That is why you have the court went on without looking into it and said that you have sought for possession. See, paragraph the page
I've
21.
seen that. I've seen that.
Then how do
I've
you
seen
take care
that,
of
my lord,
that?
but I would qualify, my lord, suggest that it's a interference in possession rather than a total ouster, my lord. Because the only allegation is that it was a vacant
So
plot
we
of land.
we allow the appeal, we dismiss the appeal, but make it very clear that the question of delivery of possession does not arise because of no relief sought for. Make it very dismiss it, but there cannot be a delivery of possession. And without delivery of possession, the other reliefs cannot be given. Mandatory injunction, because he cannot be dispossessed. Or you cannot interfere with his possession if he is in possession.
Lord,
You may have a title, nothing more.
Lord, I'm trying to bring it within the fold of 21A of that judgment, my lord. It says, while there is merely an interference with the plaintiff's lawful possession or a threat of dispossession, my lord. Now,
But you yourself say,
my lord, but
But
what
you are claiming-
transpired in the evidence is that it is vacant just with those two boards. Those two boards can be taken care of by that.
so those two boards, if you are, the question of delivery of possession shall not happen. And if there cannot be a delivery of possession, and if they are in possession, then under such it will be only a declaration. Because what you are asking, see,
Alright.
a declaration of judgment and decree for declaration of plaintiff's right, title, and interest and possession over the in respect of the soil and food land. Meaning thereby you are asking for a declaration of confirmation of possession. So if it is the relief sought for confirmation of possession, it's okay. But the question is not to disturb their possession if they are in possession.
Lord, but your lordship will hold that considering if your lordship acknowledges my title, then considering that it has transpired in the evidence that it was a vacant plot of land, then possession will automatically be deemed to be with me, my lord.
Why?
Lord,
No,
that is the
you are
paragraph
asking
I
for
wanted to read.
confirmation of possession. So under such circumstances, there cannot be an execution for recovery of possession. And that will be a fresh suit.
Alright.
And he will be happy with it. Isn't it?
My lord,
You are in possession.
I mean, but with regard to his other title, but lordship has seen the appellate court judgment. The appellate court come to a finding that since I have failed to prove my adverse possession, therefore the plaintiff gets the title.
That is what I was saying. The question, therefore, of the title out here, he may have a declaration of a right which will be only vis-a-vis you, not against the other. It cannot be a judgment in rem. It has to be a judgment in personam. That is what. Secondly, on the basis of Exhibit 20, one can say that yes, I'm not on the association of parties. I'm on one of the parties being plaintiff, one of the co-owners being a party.
But one of the co-owners, in what capacity he is? He is described as attorney as well as managing member, my lord. Not in his individual capacity, my lord. Only one party is there.
No,
my lord.
no, he
That
has
is-
stated out here in the plain,
Lord,
represented by its managing company so and so and so and so. Now you see the plaintiff is the absolute lawful owner and patata of a plot of land measuring 1 bigha so and so situated in so and so. The plaintiff has been paying the revenue here. The plaintiff further submits the entire plot of land measuring so and so which leased out to the performer defend number 4 and so and
My lord, in the plaint, nowhere is stated about the SUA company and then my lord, this formation of this plaintiff, my lord, association of persons, my lord, nothing, my lord. Simply says that plaintiff is the owner and possessor of the property. Without pleading, my lord, whether lordship will take into consideration the exhibit.
Another, how do we take exhibit 20?
My lord, two things I'd say, my lord, to that. First of all, I just need to place a concise facts, not the evidence. My lord.
Very
Now,
well. You need not say.
Secondly, my lord,
But all the material evidence, material facts needs to be mentioned.
true, my lord. Now, I say I am the owner, my lord. That's the material fact, my lord. How I prove it, my lord.
Very well, you are the owner. Very well, become the owner. But as of from the documents out there, it is not seen that you are the owner. You're not the owner. It is not seen from that.
My lord, it's a co-ownership.
We do one thing. We'll have it on some other day. We'll frame up other substantial question of law as to whether, without the relief for this, for recovery of possession, could the suit have been declared, decreed? And secondly, whether the impugned judgment and decree suffers from perversity.
My lord, para 16 for one.
I think that is these
That
two
is-
questions clear, because today, if I allow your appeal, he may
Yes.
tomorrow say out there that look here, no chance that question of law was never framed. So let us frame that to end Mr. B.D. Dekker's entire demolition of his case. Yes,
Well, para 16 for one. Mr.
not
Lordship,
necessary. I hope, this court have heard the learned counsels for the parties at length. Also, while hearing, this court finds that there are further additional substantial questions of law which arises in the instant appeal. And as such, in terms with section 100(4) of the Code of Civil Procedure 1908, this court frames the following additional substantial questions of law. Whether the learned First Appellate Court was justified in decreeing the suit in favor of the plaintiff without taking into consideration the Exhibit 4 and Exhibit 5 of the plaintiff, which shows that the Patta and the Jamabandi stands in the name of some other entities other than the plaintiff, and more so in view of the evidence of the PW3. Question: whether the learned First Appellate Court was justified in decreeing the suit in favor of the plaintiff without considering that, in view of the proviso to section 34 of the Specific Relief Act 1963, the plaintiff was required to seek for the further relief of possession when admittedly the plaintiff was not in possession as is evident from a perusal of the plaint. Anything else? Perversity?
But
What is the perversity?
my lord, the appellate court judgment matter. The appellate court has says that from Exhibit 9, it seems that the patta of the land is in the name of the plaintiff, whereas Exhibit 9 is the letter written by defendant number 1. And my lord,
Whether the judgment, whether the learned first appellate court was just, whether the judgment of the learned first appellate court suffers from perversity, inasmuch as the learned first appellate court had decided the suit, decided the appeal, merely on the context of the defendants paying adverse possession, but not deciding as to whether the plaintiffs had title, the plaintiff had title over the said property. When?
My lord, any date.
Taking into account that these freshly substantial questions of law have been framed, Mr. B.D. Dekar, the learned counsel appearing on behalf of the respondent, seeks an opportunity for addressing that the said substantial questions of law are actually not involved in the instant appeal. Accordingly, this
Can it
court
be after Bihu?
fixes the matter again on 23rd of April 2024 for further consideration.
but let it be part.
Why?
But it already heard.
Not necessary.
Okay.
Today I'm in a different mood, tomorrow I'm in.
Obliged, my lord.
Public.
Yes, Mr. Bora, your case, you see,
Yes, I have gone through that matter.
paragraph 1,
Yes,
in
yes.
fact, you see, I wrote the judgment. After writing the judgment, something while making some observations, I was in Kohima, no less of work. So I thought that let me go through Vijay Madanlal Chaudhary because it's a 467 paragraph judgment. So better what to do. So then after reading that paragraph 170,
270.
270,
Yes.
it answers everything.
But the only my submission here would be, my lord,
Eh.
regarding this paragraph, my lord. Here, my lord, the lordship kindly see that the complaint they have the provisional attachment order. That's this. I'm just pointing out one thing. The 8.1, what they have said, my lord, which is just contrary to the document. My lord. What is their argument, my lord, here for the attachment, my lord, 8.1? That it appears that the Akhtaruddin Ahmed had acquired the proceeds of crime out of the commission of this schedule of. So their case was that the all three property has been acquired in committing the schedule of. But at that time, that property was not a schedule of.
It is not required.
No,
That
no,
is
no,
what
I'm coming to that.
Hmm.
I'm coming to that. It's not required now. But that has to be, they have to place it on record that these property has been acquired for a continuing offense. Because their case
no. You see, by way of an explanation, you see, the main thing is this. Are you using the property?
yes, my lord.
The moment you use, that is why the problem arises.
No, I got it, lordship.
The moment you use it, you are using it, it comes within the ambit.
Yes, sir. But my contention here is slightly different. I'm using it. But while attaching the property, my lord, they have to specifically about because they are going beyond the jurisdiction now. Because it was not in schedule offense at that time, while I have acquired that particular property. I'm not on those other two, my lord.
Hmm.
While acquiring that particular property, which is not under the schedule offense, now it is the mandate on them
to show it that that property I have acquired by committing a continuous offense. That is my only submission here. If they are the, they are
No, Mr.
absolutely-
Bora, kindly see the Prevention of Money Laundering Act.
Yes,
Kindly see after those processes which are being given, 1 to 6,
yes,
that thereafter they mention it very clearly that all these will be a continuing offense
Yes.
on the face of it. So it is the mandate of law.
no, yes, continuing offense, I got your point, man.
Hmm.
But they have to substantiate with when they are trying to attach my property, my only submission is that they have to come out with a reason into their application of mine that applied in mind that these property also, though it is doesn't fall within the schedule offense, but this property has been acquired by me by committing a continuous offense because this has been all acquired in 97, but the offense is continuing, still he is in possession. So
No, what they have done, if you see that order, the order categorically says that from 1986 onwards, he has been doing all these things. And as such, the total income they have taken from 1986 of your family and everything to be so and so. And this is the value of the
yes,
property.
yes.
So
That-
therefore, they have done that.
No,
But-
my
but
only
Mr.
contention is therefore the paragraph 8 and 1, they have not 8.1, they have not said anything regarding the continuing of the offense. They have simply said that property also belongs to schedule offense. That's why they want to attach it. That is what the contrary to their own record.
No, not only there.
And
Mr. Bora, not only there. The entire premises is on the basis of Axis Bank. The entire case is on the basis of Axis Bank. So as such, they are thinking that the what you call the proceeds of the crime on the basis of Axis Bank. That is value of such property, which is also not there. So entire education goes. So let me, you just take your seat. Let me ask him another question which may help you with. You see, kindly see your reasons to believe. You have a copy of it? The reasons to believe? It will be there in the file.
yes, sir. 70.
Mr. R.K. Dev Chaudhary, the
Sure.
question is like this. If you see section 5,
Yes, sir.
you are to ask the order of provisional attachment prior or after recording of readings. Which one? When do you have to do that? Is it prior or after? Prior? See the reasons now. It's a 2-page reason. Come down in the on the first page down below. That these properties which are mentioned at the para of 120 of the provisional attachment order. So you have made the reason subsequent. Isn't it?
Yes, language is that.
How can you say about the provisional attachment order, the contents of the provisional attachment order in your reasons?
Attachment will come later.
So that is one. Secondly, the challenge, if you see Vijay Madan Lal Chaudhary, the challenge which has been made to section 5, there was a challenge made as regards the amendment made to the proviso 2 of section 5(1)(a). The proviso 2, the amendment which was made makes it very clear that earlier it was the use of the words was notwithstanding anything contained above. Now, the amendment shows that the amendment which has been carried out was notwithstanding which has been mentioned in one proviso, first proviso. Okay. Now, if you see the text of again the judgment of the Vijay Madan Lal Chaudhary, another very important aspect comes to light. That the first proviso stipulates that you are not going to go for an attachment unless there is a police report or filing of this case or whatever may be. But the second proviso creates an exception to the first proviso, saying that notwithstanding anything contained in the first proviso, the director can do so if he has reasons to believe. Okay? Which means it is an urgent provision, necessary invoking urgency. Why? The urgency is that he must have materials in his possession to the effect that there is a chance of the petitioner transferring these lands and all these things.
Yes.
Okay, you are not to give him the reasons. There's no quarrel. But when this court is taking up on the basis of judicial review, the reasons, therefore, has to disclose the materials on the basis of which you have invoked the extraordinary.
That has to.
Now, if you see paragraph 300, 1 and 2 of the judgment of the Supreme Court in Vijay Madan Lal Chaudhary, it categorically says that these are safeguards. Giving it to a deputy director, not to an officer not below the rank of a deputy director. Also, that he has to record the reasons as regards the existence of these. So, under such circumstances, I have seen the reasons.
Yes.
The reasons are in front of your eyes.
No.
Is there any materials? Tell me on the second aspect. Yes, you tell me. There is no reason. So therefore, although I'll hold it, that yes, this property of 1997 can be brought within the fold of proceeds of crime. I'll hold it. But I'm setting aside the provisional attachment order on that basis. However, liberty will be given to you if you have reasons to believe on the basis of materials. That will be. I can't help it because this has not tension. And apparently, the reasons say about the order. How can it say? You have to form your reasons first. Yes, I want to do that. You have done that. It can't be typo. It can't be a typo. You say that you see, these are the things out there which is there in the provisional attachment order. And as I have reasons to believe. How can you have that? Isn't that the mandate that you have to first have the reasons, and then you say that, okay, I'm going to do. Or it may be a case of the enforcement director absolutely did not have the mens rea to do that. Because they obviously had no reasons. So I'll pass the order. My judgment is almost ready. Only thing is that I wanted to, because otherwise people may say that, look here, he made this submission, say that 6/3/2097 will be completely outside. And then he comes up with the judgment. That is why I brought this.
No, no, this is absolutely all
Yeah.
right.
Yeah. So that is why I'm doing it. I'll make it again CAB. I'll deliver the judgment. My judgment is almost there. However, liberty will be given to you. You can go ahead.
Yes, that liberty is always there.
Yeah. So, but in view of setting aside this, the complaint falls. Has to go back. You may again do it. Whatever may be, liberty will be yours, but you have to have that reasons to be recorded on the basis of material. More so, if you see the judgment in P. Chidambaram's case, K. Chidambaram or P. Chidambaram, the 2019 4 SSC.
Okay.
wherein also it says. P. Chidambaram, yes, 2019, 9 SSC. Here it says that paragraph number 31. Based on the reasons of belief that an offense punishable, yeah, the reasons for such belief has to be evidence and material submitted to the adjudicating in the seal envelope in the manner to ensure, and it also says what are the reasons. It's section 5. Section 5, which provides for attachment property involved in money lender, states that where the director or any other officer not below the rank of a year reasons to believe on the basis of materials in his possession that any person is in possession of any proceeds of the crime and such proceeds are likely to be concealed. So that you have to record in your reasons. You may not give the reasons to us or to them,
Yes,
not
yes, they are
required,
not entitled.
but you have to record. Because then these reasons can be looked into by the adjudicating officer.
Because otherwise there may be a third party interest may grow up again. That's it.
Hello?
I'm sorry,
Okay.
my lord, I
Sir.
couldn't be here at the
Scavi.
first item.
It appears to be a ill drafted,
Yes.
reasons to believe that there is a contradiction in the last paragraph.
So that also needs to be done.
Okay. This is in contradiction with the last paragraph.
In view of the judgment of the Supreme Court in the case of Vijay Madan Lal Chaudhary and others versus Union of India and others reported in 2022 SCC online SC 929, and more particularly in view of paragraph 270, which gave a total different dimension to the matter in view of the decision, in view of dimension to the matter. And the opinion which was expressed, a prima facie opinion which was expressed in the earlier, at the time of hearing of the writ petition. Under such circumstances, on an off day, this court passed an order on 18/3/2024, which is reproduced here in under. To reproduce. On the basis of the said order, the matter has been listed today in the column of inverted comma to be mentioned, inverted comma close. Both the counsels appearing on behalf of the parties have been duly informed about paragraph number 270 of the judgment in the case of Vijay Madan Lal Chaudhary. Accordingly, the counsels for both the parties were duly heard, and the judgment is again reserved. Because this order otherwise does not come out there. No, you do one thing. No, you can't know. No, I'm setting aside. I'll give you the liberty. You do again. But this needs to be done. More particularly in view of paragraph 301 and Roman 1 and Roman 2. It makes it very clear you have to. Otherwise, it will be transgression to that. You do it properly. Yes.
If I appeal the respondents in this matter
You appear for?
for the respondents, I could not contact the applicant.
Come this side. Your respondent.
Yes.
Please come here so that it becomes easier for me to dismiss for default. So we dismiss for default. None appears on behalf of the appellant on call. On the other hand, Ms. S. Sanepati appears on behalf of the respondent. Was taking into account the above, the instant appeal stands dismissed for non-prosecution. Interim orders, if any, stands vacated. The registry shall send the records back to the trial, back to the court's bureau. Mr. Gore, you are just a bystander. You have nothing
Yes,
to
my
say.
lord.
So take
Yes,
your seat in the
yes.
furthest of the seats out. Who is the appellant?
Yes.
Tell me.
It's a regular second appeal. It's a regular second appeal against an order passed in a title appeal. The facts are, lordships, in regards to the plaintiffs who filed a suit in the year 2010, seeking their mother's share, 1/4, in a property which she claims to be also entitled to be got by her through her father. Now, the original landowner had 2 wives and 2 children. Now, I am one of the sons who has inherited my share of land from my father. I say inherited because by a succession, by a gift deed, in terms of which the suit property that is mentioned in the suit is also included in that. So the 3 bighas of land, which was actually given to me by a gift deed by my father, which is also now a subject in the suit, because in the suit they say that though the gift deed is not admitted by them, but they will have a different forum to adjudicate that gift deed. Neither is disputed. So the claim of the plaintiffs and the original plaintiff is that their mother's share has not been given to her. After her death in 1984, they had in repeated times apparently has come to us asking for the share which was not given to her. That is in the plaint itself. Therefore, they are entitled. They file a suit. Suit was dismissed. Subsequently, an appeal was filed. The appeal stands allowed. That's how I am before your lordships in a regular second appeal.
Mr. Pukon, first and foremost, show me in your written statement
Yes,
where you have
I will.
stated
I
about
will.
the gift deed.
Yes, I will. May I just, before that, lordships, with the permission, take the suit, if it is the suit where they have admitted about the gift deed.
No. Show me where in your written statement
I
you
will.
say that the gift deed,
I will.
mention of a gift deed.
Yes, your lordship should be kind enough to come to page 27 and extra 2 of the regular second appeal.
That I've been told.
May I just read paragraph number 7 with the lordship's permission?
Mm.
This is the written statement filed by me. Para 7. There's 5 lines from the top in that paragraph itself, your lordship. It is correct that the 2 plots of land shown in and at 5 of the plain were gifted by the original Pattada Lambeswar Das to his 2 sons. That is Indubhushan Hazarika, since deceased, and Shri Bidubhushan Hazarika in the year 1965. So Bidubhushan Hazarika is myself, and Indubhushan Hazarika is my brother, who's also been allotted a
How?
particular bigha
How?
by gift.
How?
By a
Gift
gift
means
deed.
how? Gift deed?
Yes, it's a registered gift deed.
Where
I-
it must be exhibited?
No,
I'll-
I'll just come to that, your lordship. There is a,
Yeah.
I'll come to that, your lordship. I'll come to that. The entire suit is on the premise that he's entitled, the plaintiffs are entitled for a suit of their mother in terms of the 6 bighas of land. The 6 bighas of land is not even identified in the plain. So to say that my part of the land is something which is not in my possession at all, the 6 bighas of land is not in my possession. I succeeded the land in terms of a gift deed. Gift deed is not produced an exhibit, I tell your lordships. Why? Because they admit the gift deed in the plain. Neither of us has had.
They have not
has-
admitted the gift deed in the plain. They have only admitted some gift being made in the.
That's why I said, may I just read your lordships with the
I've
permission
seen
of
it,
the plain?
paragraph 5. Paragraph 5 of the plaint, I've seen it.
Yes, I would read another paragraph to show that the gift deed is not being disputed by them. May I
I've
read paragraph
seen it,
23?
paragraph 15.
Yes. And they say, your lordship, that the plaintiff not admitted the gift is valid, and hence share of the plaintiff is gifted land also included in the said notice is available for partition.
But they
But-
will say that those gifted property which have been gifted should be taken out, and remaining land which is there, they will claim their share proportionate
the
to the
three.
gift.
In terms of the 3 bighas,
So unless therefore you bring on record the gift, the gift deed,
subsequently brought on record, not at that point of time. I admit it straight
when
away.
did you bring it?
In the regular second appeal, when they filed a 39-1 asking for a stay in the construction on my 1 because of
Did
land
you
which
file an
belongs to
order 41 rule 27?
I no, but
Then how do you bring it?
I had brought it in terms of my reply to the application that they have filed, and they himself mentioned it there that the gift deed was in existence. Unfortunately, not brought on record. I cannot go beyond that. But even in the legal notice issued to me, claiming that the right of knowledge comes from the time of that, they claim that a share of that land has been gifted to me. They say that in the legal notice, para 8 and 6. They specifically make that claim. Here they say that the gift deed that has been given to me, in which 3 bighas of land,
How do we know which land it has been gifted?
because the gift deed specifically mentions that area, fortunately. The plain does not do. The gift deed
So unless
specifically
you
says
don't bring on record the gift deed, how can one arrive at that conclusion?
it is not being brought on record.
So how do you make that submission?
The fact that they have given away their right in the plain that the 3 bighas should be kept, it should be kept separately because that is to be achieved in a different proceedings. So the 3 bighas that I
No,
succeed,
no, not in a different proceeding, Mr. Pugan. What he means is this. These 3 bighas or whatever the gift which has happened out there, you will take it out
yes,
for the time being. We are not going to claim anything on that
Right.
area which has been gifted.
agree.
But their right, which is actually, in fact, if you see the first appellate court judgment, is absolutely erroneous on the basis on which it has taken. The right of the plaintiff could have been at best 1 bigha, 2 katha, something.
Correct.
Nothing more than that. But the first appellate court not only goes to that of 1 bigha, because what he is claiming, what is the plaintiff claiming? Plaintiff claiming is that, look here, this was a grandfather. This grandfather had 4 persons who are entitled to, of which there were 4 daughters, huh?
2 daughters and 2 sons
2 daughters and 2 sons.
from 2 different wives
And as such, each daughter
has been given.
had been given land, is entitled to, not given, is entitled to. Now, what is it? As such, 1/4 of that land, which is there, or they are mentioning as 6 bighas, something, 1/4 of that land comes to this. So that is the mother's share of the plaintiff, which they claim that they are entitled to. Now you see there are 9 plaintiffs. So therefore, Schedule C is a further partition of that 9 Schedule B
1.4%, 1.4 share
of the 1/4.
of the original A, suit land A.
No, that is why everybody has made a mistake. The father gives the land which was there has to be divided into 4 parts. Of these 4 parts, 1 part is Schedule B.
Agreed.
Of this Schedule B, it has to be again further partitioned in view of there being 9 plaintiffs. So out of this, it will be 1/9 of each plaintiff will be entitled to 1/9 of Schedule B.
So
That is their thing.
in that case, your lordships, then the land which is originally been earmarked as the land that is supposed to be given to X is not even marked in the suit. So the 3 bighas of land, if it is admitted, because the 2 brothers have got two separate gift deeds. In fact, if the 2 gift deeds are,
Again, you are
considered,
making
your
that
lordship- no, the reason I'm
No, Mr. Pukman, you are making all those things which cannot be taken into account in the second field unless you bring on record that.
if I may allow to say this, your lord, if tomorrow the land is partitioned, which land would be partitioned is a question that will have to be decided in the suit. Unfortunately, it doesn't even say that this is the part of the land that belongs to me. Because in fact, in the plaint, with the patta numbers they have mentioned forms a part of the gift which has been given to the two brothers and the sister, which has got 3 quotas each. If the 6 quotas is 6 because it's to be taken into consideration, with all due respect, the land remains nothing. There's no land that is to be divided or to be for his share. Because the 3 quotas were apparently given by the father to the 2 children, to the 2 daughters, 3 quotas each, which have been subsequently sold. There's no demarcation on that also. So if A is not demarcated respectfully, your lordships, B cannot be subsequently demarcated. 1/4 share has not been demarcated. So 71,769, 7170, your lordships, there is absolutely no boundary mentioned in that. So if A is not partitioned, B cannot be, could be decided on that basis. That's all I'm respectfully saying. Because the part of that includes in the gift. Both the 2 brothers have got the gift. Same land in property. That's
Mr.
what it says.
Phukan, you may think that before going to Kohima, I was sitting out there in bench 4, bench 5. So I'll take up the matter in this manner. No. This makes it, you see, there is a particular manner in which a civil litigation has to go.
Yes.
What is this suit for? Let us assume. This is a suit for partition.
Partition.
How is a partition suit done? Tell me.
No, but they have the
You don't need boundary. Why? Tell me.
No, but even
When you are arguing a partition suit,
No,
in
I
secondary,
agree,
you tell me.
But your lordships, if a partition suit has to be partitioned on basis of a specific land.
No, kindly see. There is a reason why. Kindly see. You've got the CPC with you?
Yes, sir.
Take out Order 20, Rule 18.
Order 20. Lordship.
Order 20, Rule 18 stipulates 2 forms of partition.
Yes.
The first form of partition is Order 20, Rule 18(1),
Yes.
where the court will pass the final decree.
Read.
Read it where?
I'm reading 18(1).
Yeah.
If and insofar as the decree relates to an estate assessed to the payment of a revenue to the government, the decree shall declare the right of several interested parties in the property, but shall direct such partition or separation to be made by the collector or by a gazetted subordinate of the collector, deputed by him in his behalf, in accordance with such declaration and provision as in section 54.
Now let us stop here. With Order 20, Rule 18(1), one has to, these are lands which are accessible to revenue. So how it will be done? This will be, they will declare what is the share.
Right.
That you will get 1/4, 10th or 1 kata, whatever maybe they may say. Therefore, they are asking for that entitlement is Schedule B,
Right.
and of that, again, a further partition to be done as per meets and bounds.
In terms of
That
all the
is
other,
Schedule C as 1/9 of Schedule B.
which is the share of all the other people,
No,
which is A.
plaintiffs.
Yes.
There are 9 plaintiffs. So
9.
therefore, each will get 1/9.
Yes.
Now you kindly see, read again section 54.
Partition of estate or separation of a share.
So on the basis of Order 20, Rule 18(1), they go to 54 there.
Right.
Now see 54, what does it?
Where the decree is for the partition of an undivided estate assessed to the payment of a revenue to the government for the for the separate possession of a share in such an estate, the partition of an estate or the separation of a share shall be made by the collector or any gazetted subordinate of the collector deputed by him in this behalf in accordance with law.
Now, wait. So in view of that, Order 20, Rule 18, they go to 54.
Right.
Once it goes to the 54, the collector will do it.
Correct.
Now, how will the collector do it? The collector then will refer to the provisions of Assam Land and Revenue Regulation from 96 to 104. They will decide that.
Yes.
And then the collector will come up out there that look here, he is entitled to this amount, this share. Now, on the basis thereof, the collector will ask for claims, counterclaims, or whatever may be where a person is residing,
Yes.
so that it is seen that any empty land which is then is given to those. Or if it is cannot be then you have the principle of OLT coming into this. So this is how it will be done.
Divided.
Now, therefore, What they are asking in 15, paragraph 15 is this, that look here, this land has been given in gift, it's okay. But they would be entitled to those portion of the land which have not been gifted,
Correct.
but their share is only 1 bigger something. So
Yes.
there, from the other lands, you have to give him.
Yes. Agreed.
So that those aspects of the matter would be done by the collector.
Correct.
So you don't need those boundaries. You have to understand 15 in that perspective. Now, let me come back to you again.
Yes.
Come to this provision, come to the plaint again.
Yes.
One thing I have failed to understand in the plaint is this.
Yes, sir.
From tag number 97,
Yes.
it became patta number 97, it became patta number 241.
241. Yes. Subsequently, there has been another patta.
Okay. Now, as per the old patta,
Yes.
you see how much was the land.
Yes.
Total area of land that as per Annexure 1 and the old patta 97,
Yes.
paragraph 3.
That's at page 21.
Yeah.
Of the,
The original pattadar, since deceased, sold the following shares.
Right.
Okay.
right.
These shares, he had sold it.
Yes.
Out of hunting out 7170, 3 bighas, he
Yes.
sold 2 kathas. Then purchaser, these are the people who have sold it, and therefore he sold 1 bigha, 2 katha, 15 lechas, and the balance remained 2 bighas, 1 katha, 9 lechas.
letters. Yes. That's from the old number.
Now, as per the new patta, what has happened again, you see?
They have again sold
That
two
they-
bighas.
No, the total area was 4 bighas, 1 katha, 13 lechas.
Yes.
Sold area is this much,
Yes.
which comes to, total comes to 2 bighas, 1 katha, 16 lechas.
16 letters. Which
And
is
then
sold.
2 katha, 10 lechas.
Yes.
Now, after the sale,
Yes.
now kindly say, after the sale of the aforesaid land,
Yeah.
remains in dag number 7170, 2 bighas, 1 katha, 9 lechas.
Yes.
7169, now kindly come there,
Yes.
number who?
Three bighas. to
Because
quarter.
7169 became 8130,
Yes.
where he is
Subsequently.
constructing.
Yes.
3 bighas, 2 katha, 12 lechas.
Yes.
So after the sale made by the father,
Yes.
grandfather,
Grandfather.
the remaining land was 3 bighas, 2 katha, 12 lechas.
Yes.
Now again you see, from this 7169, 2 bighas, 4 katha, 0 lecha was
Gifted.
gifted.
Yes.
Now after this gift, how much land will remain?
Uh,
3 katha,
One-
8 lechas.
yes.
No, 3 kathas, 8
No,
lechas.
around 4 kotha, 13 lessons. 4 kotha, 13 lessons.
No. Cross-examination, we are not concerned. We are concerned with this. 7169. There is a 7169 is 3 bighas, 2 katha, 12 lechas. Of which 2 bighas, 4 kathas, 4 lechas have been sold,
I'm gifted.
are gifted.
Gifted.
Anyway, let us assume whatever may be. 7169 2 bighas, then next you come out here. The total land out here which has been arrived at is
6 bigha, what they are claiming is the remaining land here. So 2 bighas and 2 bighas, which they have come into the gifted land, is
Hmm.
5 bighas, 3 kotas. So that is the area where 3 patta numbers have been mentioned. 7169, 7170, and 712. So out of the 3 they have been what have been gifted is 2 bighas, 4 kotas and 4 lesas. That thing your lordship should be clear if your lordship reads para 4
of
of this plane. After the sale of the aforesaid land. So
Hmm.
the first part of the land is sold by the grandfather itself. Subsequent to the sale, he says there is a remaining land. Remaining land in terms of the suit, which is para 4, if we count from 7170 to 7272, is around 12 bighas, 2 kotas, 6 lesas. This is the calculation that I have made, subject to corrections. It's based
how
on the
much
plane.
as per para 4 is
As
12
as per
bighas?
para 4, which starts from 7170 and ends at 7272. My
Hmm.
learned friend will correct me if I'm wrong.
Hmm.
This is the unsold land.
How much?
It is 12 bighas, 2 kotas, 6 lesas.
12 bighas,
2 kotas, 6 lesas.
6 lectures.
Yes. Now
Okay.
this is the remaining. Now this is from both the pattas, 97 as well as the new one, 241.
How can there be 2 pattas?
No.
Where in paragraph number 2
Four.
says
That
after
is because the old one was 97, the new one is 241.
Don't you? It has to be 1 patta.
Correct.
Kindly
The
come to
land-
paragraph 2.
Yes. This
Then
has been
after settlement,
yes,
old patta is converted into new
New
patta,
patta. So-
which means
that this land was in 241, originally 97.
understood.
Right.
So this is now 241.
Yes, this is 241. 97 changed to 241.
Yes.
So 771, 7170 till 7272. This is the remaining land, he says, which is unsold land.
But where is in the plain that they have too much of land?
It's not there.
Chalo.
That is the problem in the suit. It's not there. The land, entire land is
Okay,
not mentioned.
then they
That is
have
this is the
gifted
unsold.
5 bighas,
Yes, gifted land is 5 bighas, 3 kotas, 9 lesa.
9 lectures.
Yes. Now this is from 6 different dark numbers,
Hmm.
which are mentioned on the left. 7169, 7170, 7172. Again 7169, 7170, 7172. Because because within the sold land, there were some areas which have been sold, some areas remain. So the unsold is out of 7169, there could be 2 parts of the land. One sold, one remain. So 7169 was there before also.
Hmm.
So they have sold some part remains. So therefore the gifted area is 5 bighas, 3 kotas, 9 lesa. This is what I can understand from the plane.
But 7169 as per the plain
Yeah.
was 3 bighas, 2 kata, 12 lectures.
Yes, on the top.
I hope that is correct.
Uh,
Yes, Mr. Das, is that correct? Seven one six nine, it had only 3 bighas, 2 kathas, 12 lectures. No, we are not concerned with 717. Hmm. Okay. These 3 dogs, how much total? Huh?
हाँ,
717, 3 bighas, 2 katha, 12 lectures, plus 7170 is 2 bighas, 1 katha, 9 lecture. 2 bighas, 1 katha, 9 lecture. 172 is 1 bigha, 3 katha, 4 lecture. Why again come to 11? These are the 3. We are concerned with these 3 only. 7 bigha, 2 katha, 5 lectures. They have already gifted 5 bighas,
5 bighas.
3 katha, 9 lectures. How much? 3 katha. And how much other land which is remaining? So there is no gift of this 7171, there is no gift. No gift. It's okay. 7171, there is no no gift.
No.
No gift. No gift. 7171. That is one bigha. 17 lectures. And then, and where there has been no gift? 7134, 14 lectures. 7134. And that is 2 bighas. 10 lectures. So remaining is how much? Huh?
6 bighas.
No, there are 2 bighas. And how much is there? So it can be more, 6 bighas. Total is how much? 6 bighas, 3 kathas,
17 lectures.
3 katha. So it will be 2 kathas. 6 bighas, 2 kathas, 17 lectures. Okay.
717.
So now 7169, only 1 bigha, 3 katha, 16 lectures are left. Not gifted.
Gifted is 1 bigha, 10
No,
lectures.
how much is left in 7169?
According to them, your lordship, it is 1 bigha, 3 kotha, 16 lectures.
That is it. 7169, 1 bigha, 3 katha, 16
16
lectures.
lectures. What has been gifted to me is 1 bigha, 10 lectures of what 7169 is. It's what is mentioned in the gift deed.
Gift deed is not before us.
No, but it's been filed subsequent. I'm just telling the land which has been gifted in the same numbers.
Hmm.
So 7169 is gifted,
Hmm.
7170 is gifted.
Are you opposing the partition or not?
The partition for the land which remains, I have no problem. I can't.
But you are opposing it in your plain. Now you are not opposing.
No. What I'm saying is, your lordship, if my land of 3 bighas, which has been given to me by gifted, which is irrelevant as of now, if that land is not disturbed, the other land has to be partitioned because I have nothing in that, no role in that. I have no land in that. I can't claim any land on that part. And they can claim it, whichever land is available with them. It's not available with me.
But are there land?
I don't know, your lordship, because nothing is mentioned in the plain. Subsequently, what is available, what is not available. In fact, what is sold is also not available. In fact, I have also sold my part after the 3 bighas that has been gifted to me. That's also created a third party right. It's there in the affidavit. In fact, the lands which have been sold have also been now sold to third party. They have not been made part. So in the entire, that's what I was trying to
No,
explain.
if you are not opposing, it's a different aspect. But if you are opposing, Wouldn't 110 of the Limitation Act come in? Tell me, where is your pleading out there that at any point of time these people have done anything, have recognized you? Because your mother expired in 1982. How do you take care of your limitation? There's no point of question on that. Suit can be filed at any point of time. But that is a case which does not take care of 110, where these people are exclusively doing it and you don't do anything. Neither there is a single whisper in the plane that anything happened out there. Your mother expired. When did your grandfather expire?
Sir,
That is also not there. When?
I think 74, your lordships.
Huh?
74, father expired. My father, that is their grandfather.
So grandfather expired in the year 1974. Your right, your mother's right accrued then.
Yes.
Your mother did not do anything till 82.
Okay.
You never did anything since 82. Only till 2009. How do you take care of the limitation? When he was enjoying all the property. He have never given you a single penny out of the proceeds or any. Where is your statement made in your plane that you have been visiting them, that claiming any right on that? Not a single statement is there.
12 and 13. 12 and 13. 12, it says that taking advantage of the.
No, there is no mention when.
It only says that since they've been out.
So you are admitting this, but when did you this has happened? And when have you been residing out of state? Yes. That after marriage, the plaintiff used to reside at Guwahati and did not mutate her name. So that means you never claimed. All along, you never knew anything about this thing. So 10/3/2009, you have come to know that you have been deprived. Article 65 does not come, Mr. Das, Article 65 nowhere comes into the picture. The trial court, the first appellate court made a mistake on this. But how does 65 come into the picture? 110 is the case. Just for example, if I have to accept what you are saying, that after 100 years, one fine day, the great son comes up and says, oh, look here, now I know that this was some property of mine, that I have a right. Can you file a suit? This is what has happened here. Your mother never did anything. Mother of the plaintiff happened on 82. Then you went to regularize when? Hello. We allow your appeal on that ground. Yeah.
Good.
All judgments for Supreme Court has to be bare before the Supreme Court. Therefore, this appeal arises. This is an appeal under section 100 of the CPC against the judgment and decree dated 13/12/2019 passed by the learned additional district judge Jorhat in title appeal number 9/2014, whereby the judgment and decree dated 31/5/2014 passed in title suit number 16/2010 was set aside and quashed. This court, by an order dated 4/9/2020, admitted the instant appeal by formulating two substantial questions of law. এই 3 নম্বৰটো দিব নালাগে, তে any other substantial question is unanswered. For deciding as to whether the above mentioned two substantial questions of law are involved in the instant appeal, this court finds it relevant to take note of the facts involved, which has led to the filing of the instant appeal. One, Lombestor Das, bracket since deceased. Take your seat. Expired and was the original patada of patta number. Now it will record. I'll see. Of patta number 97. Which contained various dags. That is dag number Mr. Das, do you have this annexure exhibit 1? Which contain various dags. Itu find no any I to see one C1 C1 no, it no. Record to stop. Record to move. Will record. Actually, will. Evidence की नहीं When I file, hindi ako na. Puti. Hmm? Okay. Didn't you know? Yes, any of you have the evidence with you? Or both of you are arguing without your evidence?
Sorry.
Any copy with? No, no, along with the documents, what are the exhibited documents? You have exhibited only 2 documents.
Yes,
And he has exhibited how many documents?
no doubt.
No document. Exhibit 2 is the legal notice. And you have the exhibit 2? No. No, exhibit 1 you have. Because why I'm saying is because of this document. I don't, this is the problem what has happened. This is not, there is some over interpolation of it. This should be the exhibit 1. So if that be so, kindly see what is 7, the first dark number. Huh? That is patta number. Because here in these darks, there is no, in all these darks, there is no mention. You see, in the plane. Only one ending with is 7114. It might be 711. Huh? There was one katha, 10 lectures.
Yes. The page 22 of the
They put it in English.
mentioned the page 22 of the page. Page 22 of the page.
Hmm.
7114.
<clears throat> 1995. This is a case on adverse possession. There is no payment. Huh? Hello. Okay, okay. Not necessary, not. This needs to be. One is Lumbesto Das, since the seed, was the original patadar of various darks. That is dark number 7114, 7134, 7162, 7169, 7170, 7171, and 7272. The said Lumbesto Das left behind Indu Bhushan Hazarika, left behind two daughters and two sons. The two sons were Indu Bhushan Hazarika and Vibhu Bhushan Hazarika. And the daughters were Nirmala Hazarika bracket Likharu and Monurama Hazarika. It was mentioned that this Dagna Patta number 97, it is mentioned in the plaint expressly that this Patta number 97 became Patta number 241. Agote Likrina was the owner of Patta number 97 and had various dark sets. Dark numbers when taken. This Patta number 97 became dark number 241, which had various dark being dark numbers. It has been admitted in the plaint that during the lifetime of late Lumbestor Das, na? Lumbestor Das, he had sold various plots of land. In dark number 7171, 7114, and 7134. And in those darks, therefore, that is dark number 711, 7171, the remaining land was 2 bighas, 17 lechas. In dark number 7134, only 14 lechas of land remain. In addition to that, the late Lambasho Das had lands in dark number 7170, that is Des, 2 bighas, 1 katha, 9 lecha. Seven 71762, 2 bighas, 3 katha, 10 lechas. 7169, 3 bighas, 2 katha, 12 lechas. 7272, 1 bigha, 3 katha, 4 lechas. That is totaling to 12 bighas, 1 katha, na? 2 kathas or 1 katha? As per you, there was some mistake somewhere, na? Twelve bighas in total, 12 bighas, 2 katha, 6 lechas. Mr. Adas, the learned counsel appearing on behalf of the plaintiffs who are appearing on behalf of the respondents who were the plaintiffs submitted, that in the plaint there was a mistake of mentioning that the remaining land in dark number 7171 to be 2 bighas, 17 lechas, which ought to have been 1 bigha, 4 katha, 17 lechas. Accordingly, after the sale which have been made, the total remaining land was 12 bighas, 1 katha, 6 lechas. It is further seen from the plaint that from dark number 7169, 7170, and 7172, 2 plots of land were gifted at measuring 2 bighas, 4 katha, 4 lechas, and 2 bighas, 4 katha, 15 lechas. That is totaling to 5 bighas, 3 katha, 19 lechas. It has been also specifically mentioned in the plaint that these 2 bighas, 4 katha, 4 lechas was gifted to the 15 number patadar, and 2 bighas, 4 katha, 5 lecha was gifted to the 16th number patadar. This court therefore finds it very pertinent now to take note of Exhibit 1. Which shows that the patadar number 15 was Indu Hazarika. That is, patadar number 15 was Indu Hazarika, and the patadar number 16 was Bidhu Bhukon Hazarika. This aspect of the matter was duly admitted by the plaintiff in the plaint itself. You are who? It is relevant, therefore, to mention that from the perusal of the plaint itself, it is apparent that the father, late Lombesor Das, during his lifetime, had gifted 2 bighas, 4 kata, 5 lechas of land to the appellant from Dag number 7169, 7170, and 7172. And the remaining and another plot of land to measuring 2 bighas, 4 kata, 4 lechas of the same Dag to the predecessor in interest of the defendant numbers 1, 2, one and 2.
One and
Ruma Hazarika,
1 and 2.
Manos, or predecessor in interest of the defendant number 1 and 2.
1 and 2.
And others also, many more. On the basis thereof, the plaintiff in the suit claimed that an area of land measuring 6 bighas, 3 kathas, 17 lechas remain which fell into the share of all the 4 brothers and sisters. For which the plaintiffs, who are the successor in interest of Nirmala Hazarika, the daughter of late Lombesor Das, claimed 1 bigha, 3 katha, 9 lechas. Which have been described in Schedule B. The plaintiff further sought for partition of the Schedule B land more by metes and bounds amongst the plaintiffs. At the stating inter alia that each plaintiff was entitled to 1/9 share. And as such, the said aspect could be seen from Schedule C. How many plaintiff? One plaintiff has 5.
No, there are 8.
The 9th one did not file.
He's a performer.
No, it's okay. Claiming 1/9, thereby each plaintiff and the performer defendant number 32 would be entitled to 1/9 of the share of Schedule B. This court, before further proceeding, finds it relevant to take note of that the mother of the plaintiff plaintiff. And the performer defendant number 32 expired in the year 1982. During the lifetime of the mother of the plaintiffs in the performer defendant number 32, there was no claim made after the death of late Lambeswar Das. It was only on 22/7/2009 a legal notice was issued demanding share in the suit patta, but there was no response. Prior to that, on 10/3/2009, it was mentioned that a plaintiff could come to know while processing to regularize the land records by obtaining a certified copy of the Jamabandi after the death of their mother. The suit was contested by the defendant number by the defendant defendant number 16. Others did not. By filing written statement. In the same written statement, it was mentioned that during the lifetime of the father of the defendant number 16, he gifted property to two sons, that is Indu Bhushan Hazarika and to the defendant number 16 in the year 1965. And this fact was very much known to the mother of the plaintiff, who was also gifted an area of 3 kathas of land along with another 3 kathas of land gifted to the other daughter of late Lambeswar Das. It is also seen from the written statement that the mother of the plaintiffs during her lifetime sold 3 kathas of land to Sri Anil Kumar Saitya and Sri Nabo Ratna Kumar Saitya. And the other sister, the other sister of the mother of the plaintiff had also sold her portion of the 3 big kathas of land. It was specifically pleaded that after the death of the father of the death of late Lambeswar Das in the year 1974, the mother of the plaintiffs, knowing fully well that she has received her share, did not claim any share in respect to the property till her death in the year 1982. It was only after 28 years the plaintiffs have issued a legal notice claiming a share of the property of the grandfather. On the basis of the above pleadings, 4 issues were framed. 4 issues.
Page 37,
Votes have been
the trial court order, page 37.
only 4.
4.
Okay, let me come back.
Great.
The learned trial court, by judgment and decree dated 31/5/2014, dismissed the suit on contest, holding inter alia that the suit was barred by limitation and the defendants have acquired right, title, and interest over the suit land by way of adverse possession. Being aggrieved, an appeal was prepared, being title appeal number 9/2014. Before the court of the District Judge Jorhat, which was subsequently endorsed to the file of the court of the Additional District Judge Jorhat for disposal. The said appeal the learned first appellate court framed 2 points for determination. That is whether, number 1, whether the observations of the learned civil judge, Jorhat, in respect of the issue regarding limitation for the suit is sustainable in law, ? Number 2, whether the learned civil judge Jorhat was right in the view that the respondent defendants have established prescriptive title to the suit property. Both the points of determination were held in favor of the appellant. And accordingly, the appeal was allowed and a decree was passed in favor of the plaintiffs. In paragraph number 54 of the said judgment passed by the learned first appellate court on 13/12/2019, it was observed that the plaintiffs were entitled to right, title, and interest in respect of 1/4 share equal to 1 bigha 3 kathas 9 lechas of land described in Schedule B. From out of the Schedule A land of the total land covered by PP number 97 old 241 new in respect to DAG number 7169 7170 7172 7171, 7134 7162 of block number 10, Jorhat Town, Moza. And further, 8/9 share in Schedule B land, that is 1 biga 2 katha 10 lechar out of Schedule A land. Further to that, the learned trial court was therefore directed to take necessary steps for passing a preliminary decree for partition and thereafter a final decree for partition expeditiously. In any case, within 3 months from the date of production of the copy of the said judgment. Being aggrieved, the present appeal was filed by the appellants herein who was the defendant number 16 in the suit. And this court, by an order dated 4/9/2020, had admitted the appeal by formulating two substantial questions of law which have already been quoted herein above. In the backdrop of the facts, this court have duly heard the learned counsels for the parties. Mr. R.B. Pukon, the learned counsel appearing on behalf of the petitioner appellant, submitted that in addition to the two other substantial questions of law which have been formulated by this court, another substantial question of law is as to whether the learned is on the question of limitation. Under such circumstances, this court have duly heard the learned counsels appearing on behalf of the party, more so taking into account the order dated 4/9/2020, wherein it has been mentioned that any other substantial question of law that may be formulated at the time of hearing. Accordingly, this court frames an additional substantial question of law as to whether the suit filed by the plaintiff, whether the learned courts below were justified, learned First Appellate Court was justified in decreeing the suit without taking into consideration Article 110 of the schedule to the Limitation Act 1963. In the backdrop of the above, the contention of both the parties are taken note of. Mr. R.B. Pukon, the learned counsel appearing on behalf of the appellant, submitted that from a perusal of the claim, it is apparent it is a clear case of admission In dark number 7169, 7170, 7172, a pattern number 241, 2 plots of land were gifted to the sons of late Lumbeso Das, to the two sons by late Lumbeso Das. The said area in respect to the 3 darks was 2 bighas 4 katha 4 lecha to the predecessor in interest of the defendant number 1 and 2, and 2 bighas 4 katha 5 lecha to the predecessor in interest of the defendant of the appellant. Of the 2 bighas 4 katha 5 lecha to the appellant. The learned counsel for the appellant, further drawing the attention to Exhibit 2, submitted that the perusal of the said legal notice would categorically show that it was alleged in the said legal notice that the defendant number 1 and 2 and defendant number 16 started possessing the entire land for their benefit and making construction of the roadside land under dark number 7169, 7170, 7172, leaving nothing for the share of the plaintiffs as well as the other legal heirs. He further drew the attention to the fact, to the contents of paragraph number 9 of the said legal notice, wherein it has been stated that after obtaining the copy of the Jamabandi on 10/3/2009, it was detected that the defendant number 1, 2, and defendant number 16 had obtained gift deed from late Lumbeso Das for the roadside land, depriving all other heirs very fraudulently, which the donor never entitled to gift under the provisions of law, and the said gift deeds had no legs to stand. It was therefore claimed in the said legal notice that the plaintiffs were entitled to 1/4 share from the remaining unsold land of the each dark. The learned counsel further submitted that the perusal of the legal notice as well as the contents of the plain, it would be seen that in the legal notice, it was mentioned that the total land remaining in dark number 7169 was 3 bighas 2 katha 12 lecha, and the share of the plaintiff was 4 katha 8 lectures. Whereas in the plaintiffs have duly admitted that only one bigger 3 katha 16 lectures remain from Dag numbers 7169, 7170, and 7172. The learning counsel for the appellant further submitted that although in the legal notice the right and authority of late Lambeswar Das was questioned as regards the gifts made to the defendant, to the predecessor in interest of the defendant number 1 and 2, as well as to the defendant number 16 of the land measuring 5 bighas, 3 katha, 9 lectures. But there was no challenge to those gift deeds. Drawing the attention to paragraph number 15 of the plaint, the learned counsel further added to his submission that the plaintiffs have given up the land pertaining to those portions which have been gifted. Next. Adding further, the learned counsel submitted that a perusal of the plaint would not show that in any manner that the mother of the plaintiffs from whom the plaintiffs claims their right had claimed her share immediately after the death of the father, immediately after the death of the grandfather of the plaintiffs. That is in the year 1974. During the lifetime of the mother of the plaintiffs till 1982, the mother, she never claimed any share. The plaintiff thereafter did not claim their shares for the next 28 years. And there is not even a whisper that any share or any proceeds out of the benefit or any benefits out of those lands was given to the plaintiff at any point of time prior to 2009. The learned counsel submitted that this is a pure and simple case which falls within the ambit of Article 110 of the Schedule to the Limitation Act 1963. It is a different aspect of the matter that both the courts below have dealt with in terms with Section 65, in terms with Article 65 of the Limitation Act. But taking into account Section 3 of the Limitation Act, The issue therefore arises as to whether the suit was barred by limitation. And can be very well taken up even without any pleadings. He further submitted that while in a case I'm falling under Article 65, the burden is upon the person who is claiming adverse possession. Whereas in the case of Article 110, it is the burden of the plaintiff to show that they have filed the suit within 12 years. He therefore submitted that the question of law so framed duly arises in the instant appeal for which the impugned judgment and decree passed by the learned First Appellate Court requires to be interfered with. Adding further, Mr. R.B. Phukan further submits that the learned First Appellate Court did not take into consideration the fact that 3 pikathas of land was gifted to the mother of the plaintiffs. For which she never claimed any further right. The learned counsel further submitted that even without admitting any other, even without traversing to the facts alleged in the plaint, it would be seen that from the very admission of the plaint, as on admission of the plaint, in respect to dark numbers 7169, 7170, 7172, the remaining land was 1 bigha, 3 kathas, 16 lectures. And as such, even 1/4 share of that land could not have been more than one katha, 16.5 lectures. No, it can be more than that. 2 kathas, 4 lectures. Anything else? 2 kathas, 4 lectures.
Two kathas.
Nothing more than that.
No.
In all the 3 ducts. On the other hand, Mr. A. Das, the learned counsel appearing on behalf of the respondents who were the plaintiffs, submitted that the learned first appellate court rightly decided the point of limitation. In as much as the learned trial court could not have come to an opinion that by virtue of Article 65 of the Limitation Act, the plaintiffs, the defendant, number 16, the defendant number 1, 2, and 16 had any right, had any exclusive right over the suit land. The learned counsel further referred to the judgments of the Supreme Court in the case of Karbalai Begum versus Mohammad Syed and another, reported in 1984 SCC 396. And Vidya Devi versus Prem Prakash and others, reported in 1994 54 SCC 496. The learned counsel for the respondent, oblique the plaintiff, further submitted that from a perusal of the plain, it would transpire that only on 10/3/2009, the plaintiffs, while processing to regularize the land records, by obtaining a certified copy of the Jamabandi after death of their mother, could come to learn that they have been completely excluded. And as such, when the suit was filed in the year 2010, the same was within the period of limitation in terms with Article 110 of the Limitation Act, schedule to the Limitation Act. Referring to paragraph number 15 of the plain, The learned counsel for the respondent, public, the plaintiff submitted that the plaintiffs do not admit the gift deed, the gift so made as valid. But the claim of the plaintiffs has to be adjudicated. But the share of the plaintiff has to be adjudicated. By taking into account that the defendants have got the benefit on the basis of the deed of gifts. Isn't that the claim of the plaintiff as regards its entitlement shall be done so on the basis of taking into account the defendants have got the benefit in terms of the gift deeds. You are not claiming the gifted property. How do you say though? But this said gifted land and the plaintiff share thereon is abandoned, reserving the right to claim the said share under the process of law separately. Meaning thereby, this portion should be taken into account while making the effectual partition. Isn't that? Or are you completely giving up? Referring to paragraph 15, the learned counsel for the respondent, public, the plaintiff submitted that although in the notice exhibited as Exhibit 2, the plaintiff have sought for, have challenged the gifts. But in the instant proceedings, the said gift, the said lands which have been gifted, the right in respect to those lands which have been gifted have been abandoned. Anything else? Huh? The learned counsel further, referring to paragraph number 1213, stated that the plaintiffs on various occasions have been demanding their share in the suit land. But the defendants had not paid care to the effect and were not vacating their possession from the share of the plaintiffs. Anything else? In the backdrop of the above, let this court therefore take into account the three substantial questions of law so framed in the instant appeal as to whether the same are involved. The first two substantial questions of law are interlinked. In terms with the said substantial questions of law, so formulated, it transpires that the question which have been framed is as to whether the first appellate court was justified in setting aside the judgment and decree passed by the learned trial court, granting the relief of partition on the face of the pleading that the predecessor in interest of the respondent plaintiff sold her land measuring 3 kathas, which was gifted to her by the common predecessor in interest of the parties. And the second substantial question of law relates to whether the non-consideration of the fact of the gift to the daughters of the common predecessor in interest of the parties amounts to perversity. Upon perusal of the materials on record, as well as the pleadings, how do you say that there was a gift of these 3 kathas?
In my written statement.
Pleadings is not proof. Pleadings is not proof.
In the cross-examination, may I just page 40 of the trial court's order, page 40 of the trial, para 9, around 10 lines in para 9. In the middle, plaintiff number 1, that is PW1, in his cross-examination has admitted that during the lifetime of his grandfather, he's gifted 3 quarters of land to his mother, but the said gift is not known to be with him,
Not with him.
not with him. This is his question.
He does not know if the grandfather gifted the 3 kata as share of the land of so and so. He had further stated that his age was 18 years at the time of the death of the imam. He admitted that the name of the mother was not mutated in the land or revenue record. Since earlier till the date of filing of the suit, he has not mutated his name in the suit patta. He has also stated that in the mutation case filing by the contesting heir, his mother did not file any objection. He had denied that prior to Iman, he came to know that the name of heir was not.
Mutated.
He had also stated that his relation. Where is the plaintiff's evidence in chief? Anybody has? It is apparent from the perusal of the materials on record, it reveals, including the evidence and including the pleading, it reveals that the plaintiff, the defendant, have stated categorically in paragraph number 7 of the written statement The 3 kathas of land was gifted to the mother of the plaintiff. This very aspect of the matter was duly admitted by the PW1. Who is the PW1?
Joint to the plaintiff number 1.
These people, they don't know how to make a plaint or decree. Or
That's at page 43. PW1 joint to
now, Jayanto Lekharu
Yes.
has been duly admitted in the cross-examination of PW1, wherein he is admitted that his mother was gifted 3 kathas of land by the grandfather. By his grandfather. This court have duly taken note of the judgment and decree passed by the learned trial court. As well as the first appellate court. And this court have duly taken note of the judgment and decree passed by the first appellate court. And in the same judgment, the learned first appellate court did not take into consideration the said aspect of the matter that the plaintiff's mother was gifted 3 kathas of land, which was the learned first appellate court merely granted the relief as pledged in the plaint, not even taking into account the difference between, not even taking into account what Schedule B connoted and Schedule C meant. This aspect of the matter, if had been taken into consideration, the decree which would have been passed by the learned first appellate court would have been different. On the admitted facts of the case. This analysis, therefore, goes to show that there was perversity in the judgment passed by the learned first appellate court. Passed by the learned first appellate court, dated 13/12/2019. But a question arises as to whether this court in the present facts should remand the suit in as much as this particular mistake which have been committed has to be again looked into by the learned first appellate court. The answer to the same could be answer to the above would be based upon the discussions made in respect to the third additional substantial question of law so framed as to whether the suit was barred by limitation in view of Article 110 of the code of the schedule to the Limitation Act. Limited. A perusal of the said provision would show that in order to enforce a right to share of a joint family property by a person excluded from it, the person has to file a suit within a period of 12 years when the exclusion becomes known to the plaintiff. The plaintiff has to file a suit within 12 years from the date such exclusion becomes known to the plaintiff. Yes, anybody has been the chief of PW1? Nobody is the chief? What is PW? Nobody is the chief. No, you gave only the chief of the other part. Huh?
It's, you checked it in the morning, it's there.
You gave this one the people written right. These two different one of PW2, and this is PW1 cross. So where is the chief?
I checked it in the morning, it's there in the file. May I just point out?
Congratulations.
Yes.
Huh? What paper book? Yeah. No, this I'm looking into the first appeal. I was saying if I'll এটা propose করবো বলে। They didn't know how to make the report. Ah, got it, got it, got it, got it, got it. It is there in file D. See? Where these people, they don't know where to put where. File B, they put all this. This court, in the foregoing paragraphs of the instant judgment, have mentioned, have dealt with in detail as regards the contents of the claim. The learned counsel appearing on behalf of the plaintiff, oblique the respondent, during the course of the hearing, have placed reliance on paragraph number 12 and 13 of the claim. 12, 13, and and 18. 18, na? 15, na? 18. 16, na? And 16 of the claim. As regards the pleadings pertaining to the date of their knowledge about their exclusion, on behalf of the plaintiff number 1 have adduced evidence as the PW1 and in verbatim have repeated the statements made in paragraph number 12, 13. And 16 in his evidence on affidavit. The fact clearly shows that from the above, the facts, it clearly shows that the grandfather of the plaintiff expired in the year 1974. And there is no mention whatsoever that the plaintiff mother claimed during her lifetime till 1982. There is no mention whatsoever that immediately after the mother's death, the plaintiff's claim. Although the plaintiff, number 1, at the time of the death of the mother was 18 years, which is apparent from a perusal of his cross-examination. In paragraph number 13, 12 and 13, the plaintiff duly mentions that the defendant numbers 1, 2, and 3 have been possessing the entire Schedule A land without leaving any scope to use of their share. And the plaintiffs have been demanding their share on various occasions, but the defendants have paid no care to that effect. It is also seen that the defendants all along, the plaintiffs all along did not, even after the death of the mother, take any steps. There's not even any pleading or a shred of evidence that the defendant, that the plaintiff, was at any point of time given any benefit out of the joint family property. Under such circumstances, it is in the opinion of this court that the suit was barred under Article 110 of the Schedule to the Limitation Act 1963. Accordingly, in view of the decision in the third substantial question of law so framed, the question of therefore a remand for a fresh decision does not arise. Accordingly, the impugned judgment and decree passed by the learned First Appellate Court set aside and quashed. This court, however, observes that the reasoning so given by the learned trial court is also not in conformity with law, inasmuch as the suit was not barred under Article 65, but was barred under Article 110 of the Limitation Act. In that view of the matter, the instant appeal stands allowed for the reasons aforementioned, with a cost to be deposited by the defendant. LCR return. I'll urge this court. Yes, intervener. Reviews all closed.
Extremely great.
What? It is not there. The stay was only till when? Till the disposal of the appeal. Appeal has been disposed of, so nothing in.
Extremely great.
Oh, ठीक है. I reviews of. এইটো উদ্ধাৰ কৰোঁতে মই এতিয়া
Mr. Das, I was just thinking, before taking up the earlier appeal, that why should I not make you a mediator in this matter?
Which one? Which one?
The earlier matter.
I became a mediator. I became a mediator. My lord, what has happened? That over, your lordship has passed a judgment. I was for the other side. They came. I say, it's a better you compromise. I was handling it. But they said you better compromise because the only problem will get a limitation from. Secondly, they came to a particular some point, then they decided that no, we'll not compromise. Then I said, I will not be in this case. I will not be in this case because I initiated this compromise. I will not be in this compromise. So ultimately now,
In fact, while drafting the plain, one has to be a bit careful.
yes, sir,
Plain has been horribly drafted.
yes,
Only a few words this way or that way, they should have mentioned that I did something, I visited there, I was allowed to stay there, something has been nothing. Anyway,
I
tell me,
don't
what
know,
has
sir.
happened?
But I don't know. I told one point that your entire case will go on the point of limitation. I don't know. Your just I said limitation point is the weakest point which you have. And that's
And
all-
both the courts below made a mistake of going into Article 65.
but they
65
did
was
not.
never,
But they did not went to one as I told. That was the main point.
that was the main point.
That was the main point.
In fact, it was apparent from the pleading.
My lord, here what has happened? My lord, yesterday my friend was there for DRT. I think DRT, the judge got a bit of annoyance, not mild annoyance on the bank. They say you are playing with the court, the high court, because the lawyer who appeared for the bank, as if doesn't know anything what is happening. Then my learned friend said, this is the affidavit which has been filed by the bank. Then he got annoyed. Then what is happening? Are you playing with the courts, with the high court? He said, this is now kindly see the order that will be passed by DRT. They say either you, your lordship is right. Not only appeal, proceeding has to be, so you do it, whatever you want to do it. Sir, have a copy. We understood, my
Anyway.
Yeah.
Mr. Datta, we'll have it tomorrow. I'll very short affidavit bringing on record. Okay, then 27,
27.
just a short affidavit, only short affidavit bringing on record this, or stating this. Then once it is there, then obviously what this court proposes to do is, in view of the recalling of that, then the power does not remain. So then he can proceed. First, you need to bring on record.
My lord, that's what he expects. Once the power is DRT, that they will decide. And compensation upon the court said we'll decide it. Later on, first you decide to withdraw the entire proceeding also. But you'll also express proceeding. So that's all right, let them do it.
Understood. But that this court has to now vacate the stay and permit the recovery officer to proceed. So let this be brought on by way of an appeal. So, Mr. S. Dr. the learned senior counsel appearing on behalf of the respondent bank have placed before this court and communication dated 23/2024, whereby the Assistant General Manager and Regional Head of the Bank of Baroda had informed to the petitioner that the proceedings initiated under the SARFAESI Act of 2002 have been recalled. Taking into account the above, this court is of the opinion that the same should be brought on record by way of an affidavit. Accordingly, the matter is fixed on 27/3/2024 for further consideration. The bank shall file the affidavit on a reported.
Interim order will continue till that. Interim order will continue.
Interim order passed earlier.
My lord, that's a very gray area of 34, 35. Your lordship, I have never seen that. Lordship has indicated us about 35 and 34 of both these acts.
Hmm.
This is not been, I have seen number of judgments now. After that, that part has not been decided. Where we are 2002 that act came. So that will prevail or that.
Now, there is one judgment out there wherein it says, what do you mean by law enforced? You see, if they had touched something on that section 34 of the 93 Act
Yes.
by the amendment made in 2021, then automatically the 2000 Act would have come into place. But without doing it, has to be relayed back to 93, then the SARFAESI Act is not there.
That time it was 1993, only 2002 it was. It's a part-time matter.
No, I'm here for this month.
Yeah. No, your lordship tell. That's why I'm saying.
No, this won't go. I'm only holding this pen for this month.
No, again, re-hearing of entire, that's what.
No,
We
don't
know.
worry. This matter will come for.
Deeply.
Yes, what is this?
Yeah, please, Lord. In this case, they
Whether the appellate court can pass an order on presumption of the power exercising
me.
under Order 7/7, ignoring the statutory mandate of Section. No proviso.
No
It's the proviso problem.
no provides.
Now, was that point raised in the trial court?
Yes, sir.
Trial court?
Yes.
And Mr. B.T. Dekka is sitting because of that first matter. In fact, Mr. Dekka, I framed that question of law, but you see, your issue is settled by the judgment of the Supreme Court in 1961, wherein it categorically says that if you don't raise the point in your pleadings, you cannot raise, at the first point, you cannot raise the issue of the proviso to Section 30. At that point of time. However, to trouble you, I have framed that. The second question of law which is there is clearly covered by that judgment of the Supreme Court in 1987, 160, wherein it says that you have to look into the pleadings and and whatever is claimed out there in the relief has nothing to do whether you claim it or not. But the pleadings are the most. But anyway, to trouble you. Yes, you don't have a case.
Suit filed, the suit was dismissed. And now the appeal was preferred. The appeal was declared against that order. Second appeal has been.
Where is your plane?
The lordship, the plaint is at page number 6 law.
Huh?
6,
6,
7.
7.
Start from page 6. The government is at page 7.
Plaint for what? Suit for declaration and permanent injunction.
Another reason. Now the prayer portion is at page number 30.
Declaration that the gift deed dated so and so, so and so, so. You are not in possession. Are you in possession?
No, I'm appealing for the defendant. Suit was dismissed, then they preferred an appeal. With regard to maintainability, that was reversed by the lower appellate. Against that, this second appeal. So I am the defendant, I am in possession of it. But there is no such prayer with regard to recovery. The admitted position that I have taken the entire land,
You are in possession.
I am in possession.
There is no prayer for recovery of.
Exactly. And that was the taken into consideration by the learned trial court, saying the issue with regard to maintainability of the suit.
Trial court did not look into it.
Trial court looked into, and accordingly the suit was dismissed. When the appeal preferred on erroneous presumption law.
But where is your pleadings in your written statement?
Yes, sir. Written statement losses starting from page number 17. Page, paragraph number 10 losses. That the averment made in paragraph 4 of the plain, page 19 losses, paragraph 10. Fabricated is hereby denied in photo. It is specifically denied that on 23 1996, the plaintiff came to know that the defendant number 1 got the name of the plaintiff deleted and cancelled from the records of rights in respect to the suit property, etc. As alleged there in paragraph 4 of the plain. It is specifically denied that the kidnapping number such and such is a false one. It is also specifically denied that the defendant in collusion with criminal made a false gift with the help of fictitious persons thereof. In this respect, it is submitted to the plaintiff out of his own free will and executed the gift deed in favor of his defendant number 1, and the defendant number 1 thanks of state genuine gift deed got his name included in the record of rights against the state and
Then where is that plea?
because the maintainability part we have taken on the very first.
No. First and foremost, where is your plea as regards that?
With regard
That without the recovery of possession,
because the maintainability is the first issue that we have taken.
maintainability is different, but you have to plead.
No, he lost it with regard to that particular thing, section 34, that has not been specifically mentioned, but the this suit is neither maintainable in law nor in fact. That has been specified in paragraph number 1.
No, that cannot be. There are a lot of judgments.
And in paragraph number 15, it has been mentioned the defendant begs to submit that he is the absolute lawful owner and possessor of the suit land, and he has constructed the house being holding number such and such, ward number 13 at his own cost. And the plaintiff, he transferred the land of his share to this defendant by executing deed of gift.
that after transfer of the state land, the plaintiff approached the defendant to provide some amount as loan. And on refusal by this defendant, the plaintiff out of grudge and in collusion with others filed this suit and other cases against the defendant to defraud the wrong state. So it has been specifically mentioned that I am in possession of the paper. Accordingly, when the issues have been framed, the lord will kindly see the issue by the learned trial court. This is at page number 27. Is the suit maintainable? Is the suit maintainable in the present form and manner? That was the first issue, and that was decided against the plaintiff. The discussion is at page number 28, Lordship. In course of argument, the learned counsel for the defendant persons have submitted the suit is not maintainable under section 34 of the Specific Relief Act. He added that provided to section 34 of the Act makes it clear that no court shall make any such declaration by the plaintiff being able to seek further relief than a mere declaration of title. Omits to do so, he relied upon circumstances. In view of the submission made, I find it convenient to reproduce section 34 of the Act. Discretion of the court as to declaration of status of right. Any person entitled to any legal character or to any right or to any property may institute a suit against any person denying or interest to deny is titled to such character or right, and the court may in its discretion make therein a declaration that is no entitled, and the plaintiff need not in such suit ask for any further relief. Provided that no court shall make any such declaration with the plaintiff being able to seek further relief than a mere declaration of title omits to do so. Admittedly, as revealed from the plaintiff's suit is a simpliciter suit for declaration. The learned counsel for the defendant further submitted that admittedly the plaintiff is not in possession of his proper portion of the suit premises, but there is no prayer for recovery of possession. Further added that though in para 2 of the plaintiff averts about the standing house therein, but plain sheet A does not close the description of the house, and there is also no prayer made about the standing house. The plaintiff, though made a prayer for declaration to the gifted number such and such is a false fraud gift deed, and also prayer for declaration that the mutation entry was made illegally, but the plaintiff did not pay the proper court fee as per provision of the court fee. On the other hand, the learned counsel for the plaintiff in course of the argument submitted that even in absence of any prayer for recovery of possession, if the court finds title in favor of the plaintiff, the court may in its decision grant proper release to the plaintiff who relied upon. In the cited ruling, the Honorable Supreme Court held that if the plaintiff had been in possession, then a suit near for a declaration would be maintainable. In other words, as I understood, if the plaintiff is not in possession, then a suit mere for a declaration would not be maintainable. I have gone through the cited ruling of 2006-1 JLT. The suit was for ejectment of a tenant, and the plaintiff fails to establish the relationship of landlord tenant, but proves his title, wherein his lordship in the Honorable High Court held in order view of Order 7, Rule 7 CPC. Even if a general or other relief is not being specifically sought for in the plain, such relief can always be granted by the court as it had been prayed for on the judgment. Admittedly, the suit in hand is not a suit for ejectment of a tenant. Rather, the plaintiff's suit is based on his alleged title. Section 34 of the specific relief specifically states that no court shall make any such declaration with the plaintiff being able to seek further relief than a mere declaration of title omits to do so. That being the clear legal position and relying upon the cited case of submission, as opposed to in my considered view, the suit is not maintainable in the present form. That was the finding of the learned practice. It has been reversed by the lower circular.
Now, what do you say about the declaration as regards the gift deed?
No, declaration as because the gift deed lordship, although that pending is forever, but the lower appellate court that has not been put to challenge, because the learned trial court also came to a finding, because there is only evidence, oral evidence on the part of the plaintiff. Nothing has been proved because the presumption lordship knows it.
Now, what does the trial court hold as regards the gift deed?
The finding of the gift, the learned trial court is that gift deed is not valid, but it is not false. The lordship kindly is the finding. It is the issue number 4. Issue number 4. Whether the gift deed number such and such respect of each children of the plaintiff is a forged and fabricated document and liable to be cancelled. Now the issue number 3 and 4 were taken together. There is a joint owner. It is at page number 32. page number 32 lawsuit. Both the issues are interrelated.
It's a
to each-
forged and fabricated document.
No, lordship, kindly see the finding.
Yes, page 38.
Yes.
Holding that the plaintiff is the joint owner in equal share of the suit property described in Schedule A to the plaintiff.
Hmm.
Are you a joint owner?
No, lordship, that has been denied because in our in our written
No,
statement.
no,
we
no,
made a
that
spec-
is the finding.
No, what has happened in this case,
Forget about the denial.
Yes.
The finding of the trial court that you are a joint owner.
no.
Huh?
By the mother.
Ah.
That was originally.
No,
owned
are
by
they brothers?
Yes.
Plaintiff and defendant are brothers.
brothers.
So you have denied you have challenged the gift deed. Otherwise, you become a shareholder, owner. Then on the basis of the right of, you become the owner, and if you are an owner, co-owner of your possession is then unless you accept outside. So how does the 34, the proviso to 34 would not apply?
No, here in this case, lordship, the gift deed. Because the finding of the learned trial court, the issue number 4 is answered in effect holding the gift deed number such and such as the suit line is forged and fabricated document.
Hmm.
Now, how it has been, this conclusion has come with regard to the forged and.
No, what has happened? You have filed an appeal.
No, with regard to that.
Did you file a cross appeal? Cross objection, nothing.
No.
So this finding is final.
Yes, that is
Then-
been finally. Now, only with
Then
regard-
obviously this question does not arise.
Yes.
Because you are a co-owner.
Yes.
So
That-
this question doesn't arise.
that point is
so-
there. But now
Enough.
the substantial question of law with regard
The
to the
substantial question of law has gone for a toss.
Yes.
We now dismiss the action.
section 34, because the
No, 34 doesn't apply because he became a co-owner, his possession is there by law. Appreciate that.
Yes.
His possession, he may therefore be further entitled to ask for partition at any point of time. In partition, there is no possession. Yes, the gift deed is gone, the matter changed. Heard Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the appellant. Mr. J.C. Kaur appears on behalf of the. The instant appeal arises out of the judgment and decree passed by the learned first appellate court. Dated 29/6/2011, passed in title appeal number 1/2008. Whereby the appeal was allowed, thereby setting aside the judgment and decree passed by the learned trial court. Dated 26/2/2008, passed in title suit number 22/1996. This court, by an order dated 18/11/2011, admitted the instant appeal and formulated the following two substantial questions of law. Roman 1 and Roman 2 put to it. For the purpose of deciding as to the two substantial question of law arises in the instant appeal. And are involved in the instant appeal. This court would like to take the facts which are discernible, the facts leading to the filing of the instant appeal. Infra. The plaintiff and the defendant number one are brothers. And they claim to be joint owner and in occupation of a suit property described in Schedule A to the plaintiff. Prior thereto, the mother of the plaintiff and the defendant number one was the absolute owner of a plot of land measuring 1 kata 5 lechas covered by dag number 1983 of PP number 429 of Tinsukia Mimosa. Tinsukia, on which residential houses were constructed both by the plaintiff and the defendant. During the lifetime of the mother, she gifted the said land to the plaintiff and the defendant number one by the registered gift bearing deed number 205 of 1970 dated 18/9/1970 and delivered the vacant and cast possession of the said plot of land to both the plaintiff and the defendant number one. Subsequently, on 22/3/1996, the plaintiff came to know that the defendant number one got the name of the plaintiff deleted and cancelled from the record of the rights in respect to the property on the basis of an order dated 29/10/1995 passed by the Circle Officer Tinsukia in mutation case number 510 of 1994-95 by showing a purported gift deed being gift deed number 556 of 1995 It has been mentioned in a plain 1 kata 5 letter, 2 kata 5 letter. They have typographically they made the mistake. 2 kata 5. Got the name mutated in so and so. In mutation case number 510 of 94-95 on the basis of a purported gift deed being deed number 556 of 1995. In terms with the said gift deed, it was shown that the plaintiff had executed the said gift deed in favor of the defendant number one, wherein the plaintiff, as per the plaintiff had never executed any such gift deed. The said gift deed was challenged by in a title suit number 13/1996, and along with the said suit, an injunction application was filed, which was registered and numbered as case number 10/1996. But during the pendency of the said suit, the defendant number one handed over the possession of the portion of the suit land, which was fully described in Schedule B, to the defendant number two to defeat the cause of the suit. Under such circumstances, the plaintiff withdrew the said suit and filed the present suit. seeking declaration as regards the gift deed. They're seeking declaration that the gift deed number 556 of 1995 is void, inoperative, and bad in law. The order dated 29/10/1995 passed by the circle officer was bad, inoperative, and void, and a precept be issued to both the sub-register as well as the circle officer for cancellation of the said orders. For rectifying the records, for rectifying the records, further to that, the plaintiff also prayed for permanent injunction and also a declaration that the defendant, number one, could not have transferred, has no right to transfer, hand over the possession of the suit property described in Schedule B to the defendant number two. And for demolition of the house constructed by the defendant number two. The said suit was registered and numbered as title suit number 922/1996. Thereupon, a written statement was filed denying the contents of the said claim and also supporting the deed of gift. Bearing deed number 556 of 1995 executed by the plaintiff in favor of the defendant number one. On the basis thereof, the London Trial Court framed as many as 7 issues amongst the 7 issues, issues number 3, 4, and 5 are relevant inasmuch as the said issues will relate to as to whether the plaintiff is a joint owner in equal share of the suit property described in Schedule A to the plaintiff, along with the defendant number one, and as to whether the gift deed number 556 of 1995 in respect of the B schedule land is a forged and a fabricated document and liable to be cancelled. The issue number 5 relates to as to whether plaintiff and the defendant number one jointly constructed a house over the Schedule A land. The London Trial Court took up the decision, issue number 3 and 4 together and came to a categorical finding that the plaintiff is the joint owner in equal share of the suit property described in Schedule A to the plaintiff, and the gift deed number 556/19/95 in respect of the suit land is a forged and a fabricated document. In respect to the issue number 5, it was held against the plaintiff that both the plaintiff and the defendant number one jointly constructed the house. However, the suit was dismissed on the ground of maintainability in view of the fact the plaintiff did not claimed the recovery of possession. Being aggrieved by the said judgment and decree, an appeal was prepared before the court of the judgment and decree. Question है? Huh? No. Yeah, issue there. Yeah, one. The learned trial court disposed of the suit by the judgment and decree dated 26/9/2008. Article legible and deciding the suit issue number 4 and 5. 3 and 4 were decided in Kulun, 5 were to Kulun. However, the suit was dismissed on the basis of issue number 1, holding entirely that the suit was not maintainable as the plaintiff did not seek the relief of recovery of possession.
I was also against the plaintiff. I with regard to joint ownership. That was also
That I will have to
Again.
question. But they are. Being aggrieved, the plaintiff preferred an appeal before the court of the district judge in Sukia, which was endorsed to the court of the additional district and session judge, bracket FTC number 1, for disposal. The said appeal was registered and numbered as title appeal number 1/08. By the said appeal, it is relevant to take note of that the respondent, the defendant who are the appellants herein, did not file any cross objection challenging the findings as regards the issue number 3 and 4. The learned first appellate court by judgment and decree decided the appeal in favor of the appellant, thereby interfering with the decisions made in respect of issue number 1 and issue number 5, and accordingly passed the decree in favor of the plaintiff. Being aggrieved, the instant appeal has been filed, and this court, by the aforementioned order, by the order dated so and so, framed the following, the two substantial questions, formulated the two substantial questions of law. As already quoted herein above. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of both the plaintiffs and the, on behalf of the appellant as well as the respondent, and duly taken note of their submissions. The first substantial question of law, so formulated by this court, is as to whether the appellate court can pass an order on presumption of the power exercising under Order 7, Rule 7, CPC, ignoring the statutory provision of Section 34 of the Specific Relief Act 1963. This court, in the foregoing paragraph of the instant judgment, have duly taken note of that the plaintiff and the defendant number 1 were both brothers. The said land which have been land and properties which have been described in Schedule A to the plaintiff belong to both the plaintiff and the defendant. There is no challenge pursuant to the decision passed by the learned trial court as regards the issues number 3 and 4, wherein it has been held that the plaintiff number 1 and the plaintiff and the defendant number 1 are both joint owners of the Schedule A property, and also to the effect that the deed of sale bearing a deed of gift bearing deed number 556/1995 is a false and a fabricated document. It is also seen that from the issue number 5, it has also been decided in favor of the plaintiff, holding that the properties which have been erected over the land have been jointly constructed by the plaintiff and the defendant number 1. No. Have you seen that issue number 5 by the appellate court? Then
Issue number 5.
in your file, under such circumstances, both the plaintiff and the defendant number 1 being co-owners, the possession of the plaintiff defendant number 1 over the land would be deemed to be also the possession of the plaintiff. Under such circumstances, in the opinion of this court, the learned first appellate court did not err in law in passing the decree for recovery of possession. Now, passing the decree, this is the decree passed. It is a year decree on contest and the fair portion of the plain, except for in passing the decree in favor of the plaintiff. This court further finds it also relevant to take note of the judgment of the Supreme Court in the case of C. Mohammed Yunus versus Syed Unisa, reported in AIR 1961 SC 808. It is C. Mohammed Yunus Rukmabai versus Lala Lakshmi Narayan, reported in AIR 1960 SC 55. wherein the Supreme Court at paragraph number 30 of the said judgment while dealing with the proviso to section 42 of the Specific Relief Act 1877, which is parameter to the proviso to section 34 of the Specific Relief Act 1963. Observe that it is a well settled rule of practice not to dismiss suit automatically, but to allow the plaintiffs to make necessary amendments if he seeks to do so. It was observed that in the same case, the appellant did not take the plea in the written statement, nor was there any issue in respect thereof. Under such circumstances, the plea pertaining to the proviso to section 42 could not have been applied. This court also finds relevant to take note of another judgment of the Calcutta High Court. In the case of Joy Narayan Sen versus Srikanta Roy, 26, Roman 26, Calcutta Weekly Notes, 206. Wherein the issue arose therein, as to whether it was obligatory on the part of the plaintiff to ask for partition in every case, particularly when the plaintiff claims that he is in joint possession of the immovable property along with the defendant, and in such a case, also. In the same proceeding, the question which was involved as to whether the plaintiff ought to have asked for partition, which was a further relief in terms with the proviso to section 42 of the Specific Relief Act 1877. was observed by the Calcutta High Court, learned Calcutta High Court, by the Calcutta High Court. That when the plaintiff is in joint possession of an immovable property, whether the such possession be actual possession of his share of the whole or actual possession of a part coupled with constructive possession of the remainder, he is entitled to maintain a suit for declaratory relief with a view to remove a cloud on his title created by an act of the defendant disputing his share, semicolon, in a suit so framed, comma, declaration of title is all that the plaintiff needs, and he is consequently not called upon to ask for consequential relief by way of partition. It is also well settled that the proviso to section 34 forbids a suit for pure declaration without further relief. But it does not compel the plaintiff to seek all reliefs which he could possibly be granted or debar him from obtaining a relief which he wants unless at the same time he asks for a relief which he does not want. Taking into account the above propositions of law, this court is of the opinion that the said substantial question of law to urge is not involved in the instant appeal. The second substantial question of law urged is as to whether the findings of the appellate court affirming the observations of the trial court relating to Exhibit 7 is perverse. What is Exhibit 7?
Give it.
The same question of law, in the opinion of this court, cannot be taken as a substantial question of law involved. More so, when the said question of said aspect is a mixed question of law and fact. Consequently, this court finds no grounds, no substantial question of law involved in the instant appeal, for which the appeal stands dismissed with a cost of rupees 10,000. The learned here is the LCR be returned.
Cost is otherwise cost is otherwise not.
Trial court gives 11,000. I have given 10. No, you see, when an appeal is dismissed, one has to actually give cost.
Yes.
Do you ever say in the suit why the cost is given? Nobody minds, because when you file a suit, in fact, the court fee has to be given.
Yes.
And minimum which is being taken is the lawyer's fee is 11,000 in the trial court. So I am giving you 10,000. You should be happy.
All right.
It is your one.
I'm on a slippery. I'm on a very slippery ground.
First is the question you can very well take out there in the execution. Second, this is the question whether First Appellate Court committed error in law in decreeing the suit for land in schedule of the plaintiff which is different from the land in the sale deeds. That's the question of execution. The second which is being given out here is that it has a saleable right, notwithstanding the gift deed executed earlier by him on the basis of which the defendant claimed so and so. 53A sale deed has not been done.
My lord, my prayer would be, my lord, if the court make that observation, that
What?
my lord, that we can take the objection.
Number one.
I think that there is no point taking court valuable time.
The instant appeal. Mr. Chaudhary, at the end of the day, one happiness I get in this bench is at least I am been able to do some 2006, 7, 10 matters. And these matters have been unnecessarily.
Your lordship knows the reason. My lord, even if the lawyers are ready, my lord, the cases were not listed. So the my lord, absence of proper bench.
No, the thing is like this. If, yes, you are in second appeal. Once you are in second appeal, one has to be a bit strict in admitting. If you are not strict in admitting, you can't do anything. And the sad part is about the RFAs. RFAs, the problem is, I don't know, that day I had a word with the Chief Justice, I told him that there has to be a separate bench for the RFA. If there is no separate bench, people will lose faith. The second appeal is okay, we are doing it, but who's going to do RFAs? We don't get a time to do an RFA.
RFA is a very valuable right for the matter.
It's a very valuable rate. Something has to be done. And either the pecuniary jurisdiction has to be increased. Now there's 20 lakhs is peanuts. In Guwahati's valuation, 20 lakhs is peanuts. 20 lakhs, all suits, all land suits today is more than 20 lakhs. We go to the civil court out there in Kamrup and Kamrup rural. I don't know about other places, but Kamrup and Kamrup rural. So under such circumstance, nothing. So all will come here. And once on the one hand, we, the High Court, have been pressurizing or asking the trial court to dispose of. On the other hand, these appeals are not being disposed of. People are losing faith.
But one aspect of it, regarding the cost, regarding the cost of the second appeal, just spelling the second appeals are admitted with some substantial question of law. It is supposed that when the appeal was admitted, the substantial question was framed, the court was satisfied with that there was some ground to be accepted. And after 5-10 years, it is decided, and imposition of cost may not be proper, my lord.
No. Why it is required? I tell you. A trial court, the moment you see in a trial court judgment, what is the minimum cost? Minimum cost, I'm telling you. That is in all cases put. First, with the court fee, all the wakalatama cost, all the stamp petition cost, then they put 11,000 as the fee of the council. This also happens in the first appeal. And then if we don't give anything in second appeal, nothing remains, because one has to give that also, because that all these things goes there to the trial court at the time of execution. All these things together will then be taken up in the execution, because this cost, I can't direct them to deposit here.
Yes.
That once I dismiss it on cost with 10,000 rupees, then obviously that person concerned, he then files his money execution case where he puts this additional 10,000.
I get your.
Because that is the normal process. A cost. One other cost for other things is different, but here in these costs, if you don't put it, what is the meaning out there? You are putting a hold to some execution for the last 10 years or 10 years. This is a case of 13 years. this matter has been staking and there must be a stay.
Okay.
So then that person has lost hope. At least if we don't give a cost of something also, why will the people be happy?
I get your lordship point. Because I was wondering about this.
Earlier, if you see, in a REIT, it's a different thing. REIT, when you impose a cost, you impose a cost on the conduct.
Yes.
But here you impose a cost not on the conduct, you impose on the cost on the litigation.
And the expenses that has been
Yeah.
incurred.
Just for example, normally what happens if you are, in fact, in second appeal, what happens if a plaintiff has been successful all along? Is he not? Just why in the suit he has been dismissed, there the cost has been given there. The first appeal, he again deposits 11,000. And here, if he wins the case, don't you think that he's entitled to the cost throughout?
But in case of reversal, maybe your lordship may be a little.
No, reversal is here. If it is a case of reversal, then the cost of this proceedings. But if it is a cost of others, if the plaintiff wins out here, the entire thing, he's not getting cost in the trial court. When he puts the suit for execution, he doesn't get a cost there. He doesn't get in the cost of 11. Whereas he has already paid 11,000, 22,000 has gone. Here he gets the cost out. He doesn't get the cost. In fact, if it is a case where this court passes a decree, not by the first year, he is entitled to the cost throughout. Therefore, if you see, more particularly in certain Supreme Court judgments earlier, nowadays, REIT, it's a different thing, but in civil litigation, it is always mentioned that cost throughout. Cost throughout. Means all from trial court to here, he is entitled. Whereas in REIT, it's a different. It's the conduct. The instant appeal under section 100 of the CPC is directed against the judgment and decree dated 16/9/2009 passed by the Court of the Civil Judge Dorong, Mongoldoi in title appeal number 5/2001, whereby the judgment of the learned trial court, whereby the judgment and decree dated 30/5/2001 passed by the learned trial court, that is the Court of the Civil Judge Junior Division bracket Mongoldoi in title suit number 57/1985 was set aside. This court, by an order dated 19/1/2011, had admitted the instant appeal by formulating two substantial questions of law, which are reproduced hereunder. Let this court take a note of as to whether the two substantial questions of law are at all involved in the instant appeal. The first substantial question of law is as to whether the learned First Appellate Court committed error of law in decreeing the suit for the land in the schedule of the plaintiff, which is different from the land in the sale deed, Exhibit 1 and 2. In the opinion of this court, the said aspect that is not a substantial question of law involved in as much as the same is a question of fact. Full stop. Where's your plane?
Plaintiff, your lordship will get at page 5.
8?
5.
Is it suit for?
The suit was for my lord recovery of possession
You have
Uh,
purchased it.
and for
Who has purchased it?
the plaintiff purchase
Plaintiff purchased it.
Yes. by two deeds. And the defendant's case is that the plaintiff my lord purchased from the father of the defendant. And the defendant's case is that the father had given them on gift by unregistered gift. And they have been in possession of.
Your basic question out here, because the deed had mentioned old patta number 7 and new patta number 80, which is not correct. Which should have been what?
My lord, in fact, patta number and the my lord duck number have been interchanged. That is what is there.
Yeah, the question of whether any issue was framed on that.
The issues that are framed, your lordship will find, my lord. The one issue was, my lord, whether the
You filed a counterclaim also.
Yes.
What happened to a counterclaim?
counterclaim right court, my lord, allowed the duck counterclaim. First of all,
Dismissed. What was the counterclaim for?
counterclaim is for declaration of counterclaim is for declaration of that the two sale deeds are illegal because he did not have the saleable.
So there has been. So the sale deeds now are valid. There is no challenge to that counterclaim decree. As of now, you have not challenged it. So that has attained finally. And you claimed that you are protected tenant under 53A.
53, my lord, I have to get after.
The said substantial question of law so formulated by this court, in the opinion of this court, is not a substantial question of law, inasmuch as it is a question of mixed question of law and fact. Further to that, in view of the judgment of the Supreme Court in the case of Sushila Devi, Mr. Dekka, that is Sushila Devi. Sushila Devi versus the 2003 2 SCC. There are boundaries where the executing court can look into it. Pratibha Singh versus so and so reported in 2003 2 SCC something. The executing court can very well look into the said aspect while executing the decree. Under such circumstances, in the opinion of this court, the first substantial question of law does not arise. As regards the second substantial question as to whether The courts below erred in law in holding that the Pradeep Kumar had saleable right notwithstanding the gift deed executed earlier by him, on the basis of which the defendants claim protection under Section 53A of the Transfer of Property Act. What is this gift deed?
If it is exhibited, but that is not a registered gift.
In the opinion of this court, does not arise in view of the fact that the gift deed referred to in the said question of law is not a registered deed. So being not a registered deed, these are not Hindu, these are Hindu people, na?
Right.
Okay. Huh?
Right.
Hindu or Muslim? Oh, Hindu. Okay. The said gift deed being not registered in the opinion of this court, being not registered and being of a value of rupees 100 has no right stands conferred on the basis of the said gift deed. So under such circumstances, the said substantial question of law does not arise. Accordingly, this court finds no merit in the instant appeal, for which the appeal stands dismissed and cost quantified at rupees 10,000. The registry shall remain the lower court records. Mr. Counsel, give your name. Yes.
Lordship, can we take up this matter? The
What
senior
is
has
that
left with
question of
the-
law?
He has left the brief, Lordship, I thought we can
Whether learned first court erred in law in construing exhibit 2, 3, and 4, whether the first appellate court in compliance with order 21, whether having been admitted in evidence without objection, exhibit 2, 3, and 4 could have been discarded by the first appellate. Okay, we'll have it on next Thursday.
oblige, Lord.
Yes, what is this?
But the judgment of reversal, my lord. But here again, I'll have to pay for fresh substantive.
Why?
So this perhaps did not cover.
What substantial question of law?
Lord, my lord,
You have opened your eyes after 12 years.
Lord,
Yes, tell me.
my lord, here, my lord, both the parties had inherited a particular a huge parcel of land. Now, out of that, perhaps one portion was more valuable. Both the parties allege that we have obtained this specific portion as per amicable settlement. Now, we allege that the defendant number one, though this particular portion to specific charge had fallen on our head, the defendant number one had executed a gift deed in favor of the defendant number two. Now, my lord, the trial court, after perusing the evidence on record, came to a finding that yes, there was an amicable settlement, and according to that settlement, this suit land is my share.
You are a plaintiff.
And the thing. Now, in fact, both the plaintiff and the defendant had agreed that there was an amicable settlement, but both of them claimed that the suit plan fell in their share, in their respective share, as per that amicable settlement. Now, my lord, when it went up in appeal, the suit was decreed, my lord. Trial court held that yes, this fell in my share. Now, the first appellate court, my lord, did not really go into the question of amicable settlement, rather held that it's an unpartitioned land. And I was possessing by virtue of an amicable settlement, but it says that there cannot be any partition by means and mode. I'll just quickly explain page 15 if your lordship picks up.
15.
1-5. Lord, in view of the discussion and decision of the arrived in the foregoing decision issues, I am of the opinion the plaintiff respondents alone cannot acquire any definite share or possession of the respective plot covered by periodic Patna number 57 and 72, unless the partition property is partitioned by meets and bounds in between the patta terms. The evidence of the plaintiff shows that they have been in possession over the same. No doubt that the suit patta originally stood in the name of the predecessor of the plaintiffs and the defendant number 1 and other co-pattatars. The same is in the position of unpartitioned, and the heirs of the pattatars have been possessing the land without effecting a formal partition. This being the position of any of the pattatar of the suit patta, have no right to challenge right title and interest of the other co-pattatar till effect of formal partition. There is no dispute that the plaintiffs and Horisor Debo Chaudhary are in possession of the land covered by Dak number so and so of patta number so and so, and the land measuring 1 bigha 10 lechar of Dak number 265 so and so is in possession of Horisor Chaudhary by amicable settlement. The exhibit by amicable settlement. Now, the first appellate court endorses that there is an amicable settlement. So does the trial court, my lord. But the first appellate court does not go into the question that as per this amicable settlement,
Show me a plain.
my lord, plain your lordship finds at page 36, my lord.
How are you related?
My lord, we are cousins. In fact, initially when the suit was filed, my lord, the defendant number 1 was our uncle.
You are in possession.
Yes.
You have asked for declaration that the registered deed. What is this deed?
That's the gift deed by which defendant number 1 gifted the suit plan with a specific boundary to the defendant number 2. Now, according to us, that particular specific parcel of land is our share as per an amicable settlement. They say, yes, there is an amicable settlement, but as per that amicable settlement, it actually falls in our share. Trial court held that there was an amicable settlement and it fell in our share. First appellate court, my lord, though it endorses that yes, there was an amicable settlement, but at the same breath, it holds that it's an unpartitioned land. My lord, if there's been an amicable settlement,
First appellate holds that there is a, that doesn't hold that there is an amicable settlement.
it holds, my lord. Page 60, page 15, my lord, the last
Page?
sentence.
50.
1-5, the one which I've just read, that portion. Page 15, my lord, internal page 12. Last sentence, my lord, there is no dispute that the plaintiffs and Horisor Debo Chaudhary are in possession of the land covered by so and so. This is a suit land, and land measuring so and so is
Then in that circumstance, if the first appellate court held that there was no amicable settlement,
it held there was an amicable settlement.
where
My lord, last sentence, beginning at page 15, is in possession of Horisor Das, and then at page 16, by amicable settlement.
no, it is only for possession, not for conferring title. This is what the trial first appellate court did. But I'm saying, if the first appellate court held that there was no partition,
then at least that's my second substantial question of law, which I was
That-
about to propose.
If that be so,
Yeah.
could a deed of sale be executed?
Could a deed of gift
Without
with
the
with a specific boundary that with a specific, if it is unpartitioned, my lord, if we go by what the first appellate court has said, if it is unpartitioned, so naturally the gift deed cannot have a specific boundary, my lord. It'll always be subject to partition. Now, in that case, at least if the issue is left to be decided in a partition, when eventually the defendant number 2 sues for partition, my lord, then probably he can claim a specific boundary, my lord. So long as there is no partition,
He may have a right over a particular portion of land, but not with specific.
not with specific boundary. That's number one part of it. And secondly, my lord, it had transpired that there were dwelling houses. So perhaps, though he is a distant cousin, my lord, the proviso to 44 may also come in where he will not be entitled to joint possession. So, considering all of this, could the appellate court not have granted at least the order of injunction not to enter into possession unless he partitions his supposed share which is got
That is too far.
by way of it?
That's too far. But the question is whether the learned first appellate court was justified in declaring the suit,
Dismissing.
in dismissing the suit, in dismissing the suit in its entirety after coming to an opinion that there was that the lands have not been partitioned. And the gift deed in question was had specified by
Gift deed, though may be valid in other aspects, my lord, the fact that it specifies a particular boundary, that boundary would not be binding on me perhaps as a court.
so you as if there is no partition.
Yes, there's no.
No, that finding is arrived at. What do you say about the partition file?
So partition finding, my lord, against
So that means the gift deed is okay.
gift deed is okay, my lord. There
If
again,
there is no partition, the gift deed is okay.
But-
He has a right.
therefore, I urge the first question. First of all, first appellate court says amicable settlement, but on the same breath says unpartitioned. Now, secondly, my lord, first appellate court does not reverse the findings of the trial court, whereby it was specifically held that as per that very amicable settlement, I got this share. So, first, if there has been an amicable
No,
settlement,
but that is not a substantial question of law. The court having come to that there was no finding, unless you show perversity to that finding.
I'm alleging.
Where? Alleging the would not. This court is not going to go on this basis
No,
of
my lord.
alleging after 12 years.
No, my lord, page 30, my lord, there are clear findings of fact recorded by the trial court at para
The
20.
first appellate court can obviously overturn
It can.
unless you show perversity. What is the perversity?
Lord, I'm more on the fact of if it
Yes,
chooses
it may,
to
it may
reverse.
be true because let us assume that if it is unpartitioned,
Yes.
the gift deed doesn't become bad,
Under 44, they can probably sell to the extent of their share.
but only
No
a
specific.
permanent injunction can be given till a proper partition.
Yes, yes. That's
That's the only relief one can get.
Yes.
But the question of the gift deed being bad does not arise unless you show categorically that there is a perversity to the finding.
my lord, I would argue under if
And I don't frame the question that this is perverse, whether the judgment degree. No. You have to pinpoint
I'll show.
why.
I'll show. Page
So-
30. Forward.
Where?
Page 30, your lordship find
You're going to the trial court. then.
trial court judgment where he has taken note of the oral evidence where all of them have deposed that this is the specific share of the plaintiff and he's been residing here. Now, without that disturbing that particular finding, all of a sudden the court holds that though there has been an amicable settlement, we'll hold that this is an unpartitioned land. So, if the first appellate court differs from the findings of the trial court,
Kindly come to paragraph 25. Page.
Yes.
Now coming to the fact of this case,
Uh,
that the defendant number 1 so and so is the co-partner with respect to the partner number so and so.
Yes.
The contention of the plaintiff clearly shows that their predecessor and the defendant number 1 has been possessing the land of the partner number so and other plots of land which have been inherited by them from predecessors in their thus it transpires that the heirs of the original Pattadas and the plaintiff, that is the plaintiff, are also not aware about their possession or their exact nature area of land covered by Pattadas soil. It cannot be
Yes, sir.
categorically
Clear
asserted
thought.
as to which their land would fall in their part after the effect of the
My lord, here again, my lord, injunction at least should have been granted. Even if we hold that this finding is true, my lord, that then at least I'm entitled to the injunction that you will not enter unless you enforce a party.
who is in possession.
My lord, we are in possession.
You got an injunction here.
No, my lord. In fact, the defendants have admitted that this is the land where the plaintiffs are residing. He categorically says,
Oh, is it?
Yes.
Oh, where?
in his evidence, my lord, something which the
Yes, Mr.
trial
Alam.
court has taken note of.
You see, who is the defendant number two? Tony.
One died in the
Now, your power to donate or give is not in question. But the question is, could you, unless you prove it, because you also have to prove it when the court has come to a finding that it has not been partitioned, that you have exclusive right over that portion or that portion came in your share. Yes. Where? Page? Oh, appellate judgment. Internal page. No, you have not got the memo of appeal. No, nothing else. Mr. Decker, this
No,
is
I was
absolutely
recently-
uncalled for. This is absolutely uncalled for. Huh? I'll do one thing. He has a copy of it. Let me frame these two additional questions and we'll hear it on Thursday. This court, upon hearing the parties, is of the opinion that in addition to the substantial question of law which was formulated by this court on 26/2012, the following additional substantial questions of law are involved in the instant appeal, arises in the instant appeal for consideration. Whether the first appellate court was justified in not granting the relief of permanent injunction after coming to a categorical finding that the suit land was not a partitioned land. Number two, whether the learned first appellate court was justified in not taking into consideration the provision of section 44 of the Transfer of Property Act 1882, while dismissing the suit of the plaintiff. And what else?
But whether the court ought to have reversed the findings on amicable settlement without discussing the evidence of the
whether the exercise of the jurisdiction by the learned First Appellate Court was in consonance with the provisions of Order 41, Rule 31 of the Code. List the matter, Mr. N. Alam, the learned counsel appearing on behalf of the respondent, submit, shall be at liberty to argue on the next date that these additional substantial question of law along with the earlier framed substantial question of law is not involved in the appeal. Next. This court further directs the appellant to give an entire set of the memo of appeal to Mr. N. Alam so that Alam during the course of the day. List the matter again on, we'll have it again. We have already heard it. Oh, आज की तारीख 27, 28. 28th noon. We'll have it on second. Second. Any more? No more. Why? 8 or 9, why? You are other matters. You're a lawyer. Huh? Have it on 9th of April. Yes, I may not be there, but these people may do it. Yes.
Also, I'll be not there.
Which one?
6, I cannot 6.
No, matters can John to be listed. Give your date when you want. You are an appellant.
Yes, yes.
You have some urgency?
No.
No. You have. So take a date convenient to you. Because you see, otherwise, which year?
13.
We'll have it in again on the 2nd of April. Is the matter on account of paucity of time, the matter could not be taken up, so the matter be listed again on 2nd of April.